Without any further ado, let me officially welcome you to the first regional conference focused on business and human rights in Central and Eastern Europe and Central Asia, which is also the last event of the project Lighthouse Keepers, Business and Human Rights Cooperation Network. The project benefits from a grant under the Active Citizens Regional Fund from Iceland, Liechtenstein, and Norway through the EEA grants. And before I say a few more words about the project itself, let me start by thanking all the people and institutions without which not only this conference, but the whole project and the whole Summer Academy simply wouldn't have taken place. So I would like to start by thanking Olena Uvarova, the head of the International Lab on Business and Human Rights at the Yaroslav Mudryi University, National Law University in Kharkiv, for seamless cooperation, huge heart and passion and friendship that lasts probably since like at least 2017. And I think we have a very strong connection because we were the first in Poland. Olena was the first in Ukraine to work on business and human rights. And this exchange of experiences has been of enormous gift, I think, to both of us. So Olena, thank you very much, and to your university as well. Big thanks to our partners, Alda, Association for Sustainable Democracy, represented today by our colleague Guðmundur, to the Ombudsman for Children from Iceland, Global Business Initiative for Human Rights, and others who supported the Summer Academy, so UNDP Istanbul Hub, ICRC, as well as Central and Eastern European Business and Human Rights Association and CISA Resource Hub. And our great thanks to Vistula University and in particular Academy of Finance and Business for cooperation and hosting us all here today. Thank you very much for that. I also would like to thank to all the lecturers of the Summer Academy, mentors who supervised our participants in writing the case studies, as well as a very supportive and friendly, critical, but really in a very friendly way, steering committee composed of really eminent experts in the field. Finally, let me thank all the speakers of the webinars, conference, but also everybody who joined us today here in person, but also online. We have registered participants from 28 countries, which even we were surprised with in terms of the numbers. And last not least, let me thank you to the amazing team of our own Polish Institute for Human Rights and Business, in particular, Alexandra, Gosia, Michał, who is in theory not part of the Polish Institute, but a close friend and cooperator for a number of years. And also I'd like to thank really the whole staff here at the Vistula University who are extremely supportive. And so big thanks to the whole IT team and also the administration team, like Mr. Karol Pisarek, Mr. Dariusz Chruban. They were extremely supportive. So thank you very much, because everything we are having here today is thanks to their support. And now, without any further ado, let me give the floor to Professor Wawrzyniec Konarski, Rector of the Vistula University, to welcome you in this very friendly doors of the university.
Dear Mrs. President, dear guests, first of all, I'm absolutely proud, of course, to host you here at the university, which is, as you perhaps know, the mostly internationalized university we have in Poland, with definitely more than 100 countries represented by students. So, which is absolutely our privilege and also duty and obligation in a certain sense, which means that we are obliged, of course, to pursue towards those topics which are already presented, which will be already presented in this conference. And the conference is the conference which corresponds very strongly with the nature and profile of our university. And also, I'm personally absolutely thankful to President Beata Faracik for the fact that she is also the active member of our Social and Business Council, which is the council quite active and which works together with the university authorities and which is actively involved also in very many interesting offers as far as the traineeship and different sorts of the activities for our students are concerned. We are having at the moment, I think we're having a great gap. As a human being, as a mankind, in the realities of today's business, especially if we have in mind the human rights in the business, because we are, as mankind, absolutely not united. We are still focusing a lot of the challenges. And these challenges sometimes are manifested in a very wrong way, which means that there are millions of people, including children, for instance, who are still involved in different types of the work, being badly paid and being badly treated, which means the human rights in the business remains a very important issue for the analysis. Also within such conferences as this one, which is starting right now. Let me say a few words from my perspective. A couple of years ago, I have read a book which I have with me. The book is titled Iqbal. It's a book about the small kid, 11-year boy from Pakistan, who was in fact forced to work in the very slavery conditions, as millions of such children in the entire world. We are fortunately deprived of this sort of the pathologies in Europe in general words, but still this sort of pathologies unfortunately exist in the world, which means such conferences, the focusing of the attention of the decision makers, political and economic, of those who are involved in the equal and proper treatment of those who are working right now, they remain still a very important aspect, a very important topic for us in order to go further with this sort of announcement to the entire world that something is going wrong in the world still. We are the slaves of the hyper progress, but we still, unfortunately, or sometimes we are unable to feel and to notice this sort of the pathologies. That's why the conference as this one, which we are just starting, and thank you again for your arrival, because I definitely believe your contribution towards the content of the conference will be absolutely enormous. This sort of the conference is absolutely needed. Thank you again, Mrs. President. Thank you to all of you that you decided to come and to be part of our debatable team. And please forgive me if I'm unable to be all the time with you, because I'm still working with my students. I begin in 5 minutes my class. So if there is a chance, I try to come and dash away and perhaps come again. So I really can't rely upon your forgiveness and that you justify, of course, my absence for the longer time. I do believe, despite this fact, that your today's meeting will be absolutely fruitful. And finally, it will also be a sort of the pushing point for those who are decision makers in this sphere. Thank you very much.
Thank you very much, Professor. So before I move further and hand over to Olena to say a few words to us and others from our partners, let me just start by telling why actually we are meeting here today. And I have mentioned already earlier today that today's event is organized as part of the larger project, Lighthouse Keepers Business and Human Rights Cooperation Network, which benefits from a grant under Active Citizens Fund, original fund from Iceland, Liechtenstein, and Norway. But actually, the project wouldn't be there if not the ideas that we had actually back then in 2014-15, that as we are the only civil society in the region that deals with business and human rights, We don't really want to feel so isolated. And we knew that we won't be able to make a greater change if we remain the only ones. So we knew that what we need is just basically educational and training programs that would help to train experts in the region to take this work on a broader scale. And 8 years forward, and here we finally are after the first summer academy. But luckily, I was told already during my human rights studies by some fantastic experts that human rights are not the field for those who are not patient. And indeed, this route on working on business and human rights turned out to be also a great lesson in patience and observing one step forward, two steps back dance by companies and a number of other actors. But one of the most eminent reasons for the Summer Academy was basically the fact that we're asked by the UNDP Istanbul Hub to develop a scoping study of the level of implementation of the UNGP's UN Guiding Principles on Business and Human Rights across the SES region. When I say we, it was Olena, Wawrzyniec, and myself. And one of the very clear findings, not surprisingly, was that countries in the region continue to experience a very low level of awareness on business and human rights. And at the same time, we are in the region which struggles with such issues as the absence of strong democratic institutions, the rule of law guarantees. We all experience shrinking space for civil society. We do face increase in corruption across the region. We do have ineffective remedy systems for the victims of business-related human rights abuses. And obviously, the region faces also such challenges like the ones to ensure corporate responsibility for human rights, in particular in the area of labor rights. We have the issues with occupational health and safety, environmental safety, as we'll see in the case studies presented throughout those 2 days. A number of issues are arising on this junction of human rights and environment protection. We do have a number of discriminative practices still present around us, as well as very particular business models, which actually already at the very heart of them do have human rights violations in a way ingrained in the way they operate. And they really need to tackle the very business model to be able to really ensure that they respect human rights. And we do have also the lack of effective mechanisms for communication between the local communities and business. And one of the issues that companies, at least in Poland, find very difficult is a proper stakeholder engagement, because meeting once per year in a session is really not what we mean by meaningful stakeholder engagement. So if we wanted to change it, we knew that we need to start supporting willing individuals across the region. And we are really happy to see some of you today here. Simply on their route to obtain more knowledge in the field and just to be able to start driving change in your own countries. And that was the purpose of the Academy, to equip a number of people with the knowledge necessary to drive change in the region. And well, the time will show if we have succeeded, but we know that many of you have really great passion. So I think we are really, really optimistic about it. And I'm so happy that already one of the participants of the Summer Academy actually started an NGO working on business and human rights, the first NGO working on this field in Bulgaria. So there are some tangible outcomes of that process already. And that's just one example. And now I'll hand over to Olena Uvarova, the co-organizer of the Summer Academy. I'm always losing the titles, but.
Yeah, hello everybody, and I'm so happy to see you all today. And for me, it's really meeting with great BHR friends, and many of them we met with you online only, and it's a great chance to meet in person. And as Beata said, we dreamed about this day and about actually this opportunity to provide the summer beach or summer academy for the region and such conference for the region. My congratulations to all of you, and my gratitude to all participants, to all alumni of our summer academy, and my gratitude to all our lecturers, our partners, because from my perspective, this summer academy became the unique business and human rights school, because so many great names were brought together thanks to Beata, and actually thanks to this passion on business and human rights, because all who participated in this academy really business and human rights people. And as Beata said already, of course, we hope that this conference and this summer academy will be the first step to address to that business and human rights challenges and developments in the region. And in particular, we know that today the European Parliament should vote for the draft of the directive, and Professor Markus Krajewski now will touch this issue in his presentation. And I was very glad to see the special point. I don't know if I can say already that one of the questions which will be covered is about the impact, possible impact of the directive on the region, or role of this directive for the region. And I should say that this issue is still, I would say, in the shadow, and we really and of course, the directive will have and even potential to have of this directive already has the different impact on the EU countries from the region and for the non-EU countries from the region. And I should say that non-EU countries of the region, of course, pay very low interest to this directive, but to be honest, 2 days ago, I participated in the conference in Lisbon, and I was asked what actually could mean this directive for the region, for non-EU countries of the region. And I said that, of course, we could see very different impact, but what I can say for sure, such countries as Ukraine, as Georgia, as Moldova, as Central Asian countries, I believe so, actually will consider this directive is an important sign to have its own changes in its own legal systems, because all of us know that what we can say for sure is that our countries take all the European Union's developments seriously. And just for that reason, I am very supportive about the adoption of the directive, despite that fact that there is a critic, some critic about the directive, but still it will be an important step. But again, what our countries need to have such analysis of the impact by the national experts, not just by experts beyond of our countries, because just national experts could understand the local context and could build this analysis, of course, on the views of international experts, of the EU experts, but we need to have this internal expertise and to build our understanding of these developments based on our local context. And that's why, again, we hope that alumni of our summer academy will be such national experts. And also we see that there are some some positive developments in our regions related to business and human rights, and many countries, not many, but some countries of the region preparing national baseline assessments, are working on national action plans. But again, to be honest in this audience, these processes are initiated in many cases by external actors, by international partners. These processes could not be effective as they could be without national expertise. And we feel very, very much now that there is a lack of national expertise in our countries. And that's why, again, we hope so much that you will be these drivers of changes. So thank you very much that you are part of this process.
Thank you very much, Olena. And unfortunately, we weren't able to have all partners with us today, but we do have the messages to you from two of them, and one will listen now. It's from the Ombudsman for Children in Iceland. And I'll just ask our colleagues to perhaps dim the lights in front of us.
Dear all, it was a pleasure to take part in the project Business and Human Rights Cooperation Network. Unfortunately, I have competing commitments today and tomorrow and cannot be with you in Poland. The project gave us an opportunity to learn about various ways the business sector impacts children and how negative impact could be prevented. This is a topic my office would like to work further on in relation to children's rights and business principles. It is inevitable that the activities of companies affect the lives of children and their rights, whether directly or indirectly. Children and young people have interests to protect as consumers, family members, staff and future workers and managers. Children and young people generally have limited opportunities to influence society, and all too often are decisions made that have a direct impact on their lives without them being given the opportunity to express their opinions and have them considered. The impact of companies and the lives and development of children can be long-lasting and in some cases permanent. It is important to build awareness and knowledge of the business principles in Iceland, both when it comes to the private sector as well as within the government. I would like to see child rights impact assessment, CRIA, carried out regarding business activities as well as within any proposed law, policy or budgetary allocation, which affects children and their rights. Most of the discussion here in Iceland is about, when we talk about children's rights and business, is about when they start to work. The idea of working hard is deeply rooted in Icelandic culture, and it has been generally accepted that it's good for children to experience participating in the labor market from an early age. My office is often concerned about children's safety within the workplace, their salaries and working hours. The working environment for children and teenagers need to be safe, and they should receive guidance and be informed about safety measures. In the webinar in the autumn 2022, we did share our experience. In one of the seminars within this project, I spoke about the importance of engaging children and stakeholders in situations when human rights due diligence would find it necessary. Children do participate in most sectors of our public life, but they are not listened to and they have limited ways to influence their environment. And I spoke about our children's forum, our young advisor group, and other means to engage children. When children take part in policy making and decision making, it also strengthens their participation in social debate and social and democratic work. Children who get the opportunity to participate learn to show initiative and to be solution-oriented. They realize that they can have influence, which then encourage them for further participation. They often see opportunities for improvement and progress in their own local environment, and thus the children's participation can become a link in a long chain of development and progress in society. I wish you all an interesting conference, and I hope to see you all in the future. Thank you.
And now I would like to give the floor to our colleague from Alda, Association for Sustainable Democracy, namely Mr. Guðmundur Haraldsson, who is a board member of Alda. And I should stress that we, as part of the project, we did have Summer Academy, but we also had a second strand of working on ethical framework of cooperation between NGOs and business. And Alda was very instrumental in leading the workshops on this topic. Guðmundur, the floor is yours.
Good morning, everyone. Thank you for having me here today and inviting me as a representative of Alda to be here. Alda was founded in 2010 in aftermath of the economic and political meltdown in Iceland. It's occurred 2 years earlier. The founders recognized that the prevailing ideology that led to the meltdown was still intact, and a new one had to evolve. One built on democratic principles, so that Iceland could become a place of deeper and broadening democracy. This is still our aim, the aim of Alda. Recognizing that democracy is strongly linked to the functioning of the economy, Alda has always had a focus on economic ideas as well as political ones, or democratic ones. We incorporate sustainability into our thinking, as it is a fundamental element to democracy and human flourishing in general. In June 2022, Alda organized a workshop in Reykjavik, Iceland, as a part of the Lighthouse Keepers project. Representatives of 12 NGOs attended to discuss the role of code of ethics in the life of democratic associations, especially when cooperating with business. Given how important such associations are for the functioning of democracies, the implementation of such rules is for their transparency and continuing trust in society is quite important. The meltdown in Iceland shed a light on how some associations had failings within our society at the time, and the workshop highlighted that there are essentially two ways to think about code of ethics. Another one is I would like to stress that, so this topic is very relevant to Iceland, like how code of ethics can guide you in running your association so you can have a good trust within society. The workshop highlighted that there are two fundamental ways to think about code of ethics. One of them being kind of guiding light, where there are social pressures used to keep people conforming to the rules. Another one is more rule-based, with disciplinary options being available. Both have their pros and cons, and both have their different applications. There was no consensus on which one was better. This may not come as a surprise. So finally, I just wanted to mention that Alda is a member-based association and kind of aspiring think tank. And we work on various things related to democracy and sustainability and economic things. One of the topics we have worked on is working time. So we have promoted the idea of short-term working hours within Iceland. And this stems from our recognition that democracy only exists when it can be practiced, which requires time and effort. Shorter hours also improves quality of life, social relations, and can have positive impact on the environment. Iceland has made some progress in this area with nationwide implementation of shorter working hours. And this is one area where I believe Alda has made some progress, or has a positive impact, I should say. And yeah, here I conclude. I just want to thank you for your attention. I hope this conference will be both useful and enjoyable to you. Thank you.
Thank you very much, Guðmundur. And we are now moving to the very final message in this opening session, which will be coming from Ron Popper, who is the CEO of the Global Business Initiative for Human Rights.
Hello, I'm Ron Popper, Chief Executive of the Global Business Initiative on Human Rights, which is a group of more than 20 multinational companies which are working to embed respect for human rights in their daily business operations and value chains. Many of those companies have business operations and value chains in Central and Eastern Europe and Central Asia. The GBI has been closely involved in the past year in the planning and delivery of parts of this academy, and we're proud of that ongoing involvement. We see a strong need to help raise awareness about human rights and the business role in strengthening respect for human rights. When I was mentoring a course participant from Poland, he produced a case study from the garment industry which focused on truly dreadful working conditions, poor pay and exploitation, mainly of women workers. That was happening in Poland. It was clearly not an isolated case. Rights were being trampled on, labour laws were not being enforced, and grievance mechanisms were unknown. It reminded me that yet again, we have rights issues everywhere, not just in faraway countries, but on our doorsteps, in Eastern Europe and Central Asia, and indeed also where I live in Western Europe. We have garment sweatshops in central Italy, around Paris, in central England, dreadful conditions for agricultural workers in the Mediterranean countries and elsewhere, the conditions under which lorry drivers work throughout Europe. The list of rights abuses is sadly rather long. My point here is that labour and human rights abuses are all around us. As companies, as members of government, as members of civil society, turning a blind eye causes and excuses human harms, negates social progress, and is also bad for business resilience and continuity. Sure, there are many examples of good business behaviour, but there are still many, many examples where companies, large and small, are cutting corners and causing harms in the drive for increased profitability. I understand full well the profit motive, but it really is time for a reset between customers and suppliers, so that customers work with suppliers, not against them, that they make a bigger effort to take into account local contexts, local market conditions and needs, rather than basing their relationship only on price and profitability. Businesses that continue in the old paradigm will, in the medium term, lose their business connections and supplies as workers go sick, lose motivation, and seek alternative employment where it's available. I think that you on this course have tremendous opportunities in your daily work and lives to seek and implement change at different levels in government, in business, and in civil society. Huge tasks for sure, but do persevere. As I say, my organization, the GBI, is committed to supporting this work in your region, even though we are not physically present over the next few days. You are in extremely capable hands with Beata and Olena and others who are true stars in this field. So enjoy the conference, and we look forward to working with you further in future. Thank you.
I haven't listened to this message till the end when I was checking for compatibility, so it was a very nice surprise from Ron actually at the end. But now I would like to say that we are through the formal opening, but I hope that you've heard quite a few important messages from our speakers. But now I would like to give the floor to our key speaker, Professor Markus Krajewski from Center for Human Rights at Erlangen Nürnberg, Friedrich-Alexander-Universität, who will be talking to us about the role of domestic regulations in advancing human rights due diligence. And he'll give us an example of the case study of the German supply chain law and its impact on Central and Eastern Europe and Central Asia.
Thank you very much. Good morning, dzień dobry, and dziękuję bardzo. That's about the only Polish words I can say, and na zdrowie and jeden people, but apart from that, thank you very much. Thank you, Beata, Olena, the organizers and the funders of this conference for inviting me. It's a great pleasure and privilege to be giving the keynote lecture. I'm not entirely sure what a keynote lecture is, but I hope I can give some ideas for the further discussions. So Beata asked me to speak about the role of domestic regulations in the field of due diligence for human rights, specifically, of course, regarding certain due diligence laws. And she also asked me to use the case study of the German supply chain law and its impact on Central Eastern Europe and Central Asia. I always feel a little bit uneasy when I talk about the impact of German laws on Eastern Europe. So maybe I can sort of hide away from that responsibility by also turning to the European perspective. So I've planned to sort of speak about this topic in 5 steps. So first, I want to say a few words about the background of human rights due diligence legislation. What is it that we are talking about? What are some of the main principles, some of the legal bases? Then I want to sort of, as I was given this task, to speak about the German Supply Chain Due Diligence Act, but then move to the European Directive on Corporate Sustainability Due Diligence, partly for the reasons that Olena already mentioned, because of course, many of the countries in the region that we are discussing are either member states of the European Union, aspiring to become member states of the European Union, or in some other way connected to the European Union. And so that will then lead me to talking about the impact of these laws on Central Eastern Europe and Central Asia, and then I come up with some conclusions. So let's start about the background on human rights due diligence legislation. I should say I come to this topic from a legal perspective. I'm a lawyer by training. I teach at a law school. My background is in public international law. So that, of course, is a particular angle. And I'm not saying it's the only angle or not even the right angle, but it's my angle. And I'd be happy to, of course, also hear from other perspectives, specifically maybe from also a business perspective, an NGO perspective, a practitioner's perspective, but also, of course, from the perspective of private law. So when we talk about these laws, I think it's always important to think about, well, where does this come from legally? And my starting point, as I said, as a public international lawyer, is that the starting point, the legal basis of these laws are international human rights obligations of the states. So all states that we're talking about have human rights obligations, some of them based on international treaties, human rights treaties, both global treaties and regional treaties. But in addition, of course, there's also customary international law. So as a public international lawyer, I feel I'm standing on safe grounds when I say all states in the world have international human rights obligations. None of them fulfill all of their obligations. I think that's pretty clear. But that doesn't mean that these obligations do not exist legally. And those of you who study human rights law will also know that one particular important element of these obligations is what we call in human rights law doctrine, the state obligation to protect. So there is a duty to respect, but there's also a duty to protect. And that translates, when it comes to practical policy, practical legal work, translates into regulating corporate activities. So far, so clear, so far, I think that's global consensus. The question arises, what kind of companies, and what is the scope, the territorial and the jurisdictional scope? And when I analyze these laws and when I analyze the legal basis, I think it's useful to distinguish between what I call the jurisdictional scope and the territorial scope. For me, the jurisdictional scope is usually not the problem, because what states are doing, they're regulating companies which are either incorporated in their legal system or operating on their territory. So from a public international law perspective, they all have the sovereign right to do so. They have jurisdiction over these companies. When it comes to the territorial scope, the question turns from regulating company to protecting human rights. And this is where the debate that many in the room will be familiar with, the debate about extraterritorial obligations, actually comes from, or actually where it's situated. So it's the question, whose human rights are we looking at? Are we protecting? And of course, we are protecting the human rights of the individuals, of the human beings that live on the territory. And I'm glad that in the opening, one of the opening speech, there was also reference to the fact that many of the human rights violations we're looking at are not just human rights violations far away, but rather sometimes just around the corner. The region in Germany where I live has also some agricultural businesses, and there is often an issue about forced labor, modern slavery, when it comes to sort of workers in the agricultural business coming from Southeastern Europe. So the question is, again, when it comes to the extraterritorial obligations, what about protecting human rights in other countries? And we do have quite an interesting development. If you read the guiding principles, this is principle 2, and specifically the explanatory paragraph to it quite closely, you realize that, should I say John Ruggie or should I say the Human Rights Council? But anyway, whoever sort of is the father or the authors of the guiding principles was a little bit reluctant, saying, yes, states can do that, but there's not necessarily obligations of states to do that. We did then have at the same year the Maastricht Principles on extraterritorial obligations in human rights, which came out much stronger, and many of you will know the Maastricht Principles are a set of guidelines adopted by a group of experts. So it's not an official source of human rights or any form of international law, but came out quite strongly with this idea that states do have an obligation. And then it was, I believe, in 2017, when the Committee on Economic, Social, Cultural Rights, the treaty body that oversees the implementation of the International Covenant on Economic, Social, Cultural Rights, came up with its general comment number 24, in which it, depending on how you read it, but made it pretty clear that yes, there is an obligation of states to regulate also the extraterritorial impact of companies that they have jurisdiction. So I think that's the legal basis of the laws that we talk about. So what are some of the key questions and principles when we look at these laws? And this will also be sort of the analytical framework of when I look at the two legal acts that I want to discuss. We discuss which companies are covered, large companies, small companies, how do we define that, number of employees, annual turnover, sectoral scope. There are some regulations which only apply to certain specific economic sectors, others apply to all sectors. Of course, the scope, is it all human rights? Is it just modern slavery? Is it just child labor? Does it also include environmental obligation? If it includes environmental obligation, what kind of obligations are we talking about? And then, of course, what are the actual obligations? And I think the picture that is emerging, at least in the last couple of years, is that the obligations are due diligence obligations based on the guiding principles. And we'll look into that maybe a little bit more detail in just a moment. And of course, these obligations also include reporting obligations, which are, as you know, of course, also part of the due diligence. Now, when it comes to laws, and this is, of course, what interests lawyers specifically, is how are the laws being implemented? How are they enforced? And again, I think we have a trend, or at least in the debate, but also in the development of the laws, where we can see there are two avenues. Sometimes they are alternatives, sometimes they are cumulative. We can talk about private enforcement, and there's been both in the field, but also in the literature, a lot of discussion about private enforcement, both regarding civil liability. Many of the tort claims that we discussed, both in US courts, but also in English courts, in Dutch courts, claims against companies are based on tort law, so there are civil liability cases. There's also, of course, the idea of competition law, unfair competition, which is also part of private enforcement. I haven't seen much literature, much academic literature in that area yet. I think that's still an unexplored field. But of course, public enforcement is the other avenue, both administratively, when it comes to administrative law, and also when it comes to criminal law. So there has been a development, and many of you in the room know this and have been following and studying this for many years, but I just wanted to sort of reflect on this again, where does it start? And some say the story starts with the transparency and reporting laws. The UK Modern Slavery Act is often cited, but also the EU Non-Financial Reporting Directive. And basically what these laws required companies was to report and to be transparent about what they're doing. The next step is sort of what I call general human rights due diligence laws, where basically the law just specifies that companies have a due diligence obligation. And here, of course, the most important historically example is the French Loi de Vigilance, which basically just says companies have to adopt and implement a vigilance plan or a due diligence plan. I also count the Norwegian Act, the Norwegian Transparency Act in this context, because it is also an act which requires companies to engage in due diligence, but it doesn't really specify what that means. The next level, I don't want to call it the next level, but maybe historically or systematically, the next step would be laws which make it very detailed, clear what due diligence means. And you're probably not surprised that at least the legal tradition that tries to come up with very detailed definitions and be very, very precise is the German legal tradition. And whether the European tradition follows that, we will see and discuss maybe later. So let me now have a very quick look at the German Supply Chain Due Diligence Act. And stay with me for just this very brief commercial advertisement here. So this is what German lawyers do if they don't know what to do, right? So new laws come out and they write commentaries. So if you think that the German legislator is already producing big laws or long laws, detailed laws, just let the German lawyers and academics enter the room. And there's not a single clause in any law that we cannot blow up into dozens and dozens of pages of explanation. I'm partly joking about this because it's actually happening, but it's also important because that's the kind of instrument which influences practice. And this is why three colleagues and myself sort of endeavored in this direction. And we're in the final stages of editing one of the largest commentaries on. And now you can see whether you move from German B2 to C1, whether you can say Lieferketten-Sorgfaltspflichtengesetz really quick. Because that's the official term of the German supply chain due diligence law. So the legislative history is surprisingly short, at least for a German law. The basis is the National Action Plan, which relied, the National Action Plan on Business and Human Rights, the first version, which relied on voluntary implementation of human rights, a very German approach. First, we believe and trust our businesses that they do the right thing. But there was already in the National Action Plan this indication that there's going to be an evaluation. And if it turns out that German businesses are not following it, the voluntary implementation approach, then the legislator may actually act. And then the government asked a consultancy to actually do an evaluation. And I have to say, to probably surprise of everyone in Germany, it turns out that only 13 to 18% of the German companies were actually engaging in this. And this, of course, then increased the pressure. Of course, there was a civil society campaign toward a mandatory due diligence law. And then, and I put this on the slide just because it's very un-German. The government proposed a law in March 21, and the law was adopted in June 21. Normally, we need at least a couple of years. In this case, not Germany needed only a few months. The reason is we had a general election September 21, and the sitting government at the time didn't want to give the due diligence campaign to the opposition. So it was very clear some members of the Conservative Party said, we are going to adopt this law because this will not be something you opposition will campaign on. And there are a couple of things in the law which explain, or which can only be explained by this very quick process. So what is the coverage? The law covers companies registered in Germany and companies with a secondary establishment in Germany. It's only for large companies. From January of this year, it applies for companies. It applies to companies with more than 3,000 employees. We don't have a register, so there's different estimations. One that I found is that it's about 900 companies. Some estimations are it's more. Anyway, from January next year, it will be companies with more than 1,000 employees, which could be up to 5,000 companies in Germany. Foreign companies only offering goods and services in the German market are not covered. We will see that this is a significant difference to the European draft directive. What is the substantive content? And here, of course, now I could speak for hours and hours. I won't, because for everyone in the room who is a little bit familiar with the guiding principles, most of this will sound familiar. So the core is the requirement to exercise human rights and environmental due diligence. There are a couple of environmental obligations in the law already. That includes a risk management system, risk analysis. It includes preventive measures. The law mentions a policy statement as part of the preventive measures. The purists among us in the room know that the policy statement is not part of the due diligence, so that's actually a mistake in the law. Contractual assurances, trainings, remedial measures are also mentioned, sector-wide initiatives, a plan to mitigate human rights risks. The termination of a business relation is also mentioned, but also as an ultimate ratio. So only if there's no other way of actually avoiding the human rights risks should the business be terminated. There's complaints mechanism, an entire provision on complaints mechanism, procedure, internal documentation, and public reporting. The scope, it's quite interesting, covers all human rights. The legislator decided to say, we'll talk about the rights enshrined in the Covenant on Civil and Political Rights and the rights enshrined in the Covenant on Economic, Social, Cultural Rights and the ILO Core Labor Standards Convention. Now, some of you may know that we used to have 8 core labor conventions. Now we have 10. Now, I'm pretty sure that the German legislator has to change that, maybe in the context of the implementation of the due diligence directive. There's a specific focus on a number of salient human rights violations. And I find that an interesting approach in the law. The law actually doesn't say these are the human rights. You businesses now figure out what the problems are, but rather the law tries to sort of tell the companies, explain to companies what are the specific risks that you need to look at. So it talks about, of course, it talks about child labor. Of course, it talks about forced labor, but it also talks about risks concerning water and soil pollution, enforced evictions, torture, and other ill treatment by security forces. So it tries to give companies an indication of what is it that you may have to look at. Of course, the list is not complete, and of course, there's more, but I find that from a regulatory perspective, quite an interesting approach. There's also some environmental obligations. 3 multilateral environmental treaties are mentioned. Again, I think this is an interesting development because specifically when we look at the European directive now, but also at other initiatives, it seems that we're moving away from a human rights-based focused due diligence towards a sustainability-based due diligence, which includes both human rights and environmental obligations. So a lot of the debate is about, well, what's covered? What's the extent of the obligation? It's clear, of course, the own operations of the companies, which includes any subsidiaries, and then also the direct supplier or the first-tier supplier. So the law says focus on your own cooperation, your own operations and your first-tier supplier. That's a political decision. It's part of the political compromise. I think it's both politically, practically a mistake. I think it's also systematically a mistake. And it's probably not going to play such a big role in practice anymore. We'll see about that, because what the law says is you need to look at the indirect suppliers. So the entire supply chain, if you have substantiated knowledge of a potential violation. So, and that's of course a very German way of doing it. What is substantiated knowledge, right? Now you can see why we need to write these big commentaries to explain what that means. Probably practice in companies, but also practice in the agency that oversees the implementation will be that it's a broad understanding of substantiated knowledge, but we'll see. Enforcement. So when the German law came about, there was a lot of debate about all these cases, these wonderful cases in the UK, right? Everybody talked about these cases. The NGOs loved them, right? And so they said, we want to have these cases in Germany too. And then the French came up, and there was also sort of this idea of reliance on civil enforcement. The French, as you know, sort of forgot to say which courts are competent. So this is why it took a while to find out which courts are competent, but they settled that now. So the Germans said, well, we believe in administrative administration, we believe in administrative enforcement. So they said it's going to be administered oversight by the Federal Office for Economic Affairs and Export Control. Now, the funny thing is that office had no idea what human rights due diligence means. They had no expertise. And so the first thing, they had to hire about 60 to 70 experts in the field who are now implementing this law. It's a rather strong enforcement mechanism. Of course, it can use administrative measures and fines. It can actually also implement administrative fines to, in particular situations, almost up to 2% of the annual turnover of a company. So compared to other administrative fines, that's actually quite large. When it comes to civil liability, the diligence law is pretty clear in saying that you cannot you can't base civil liability on the law itself, but that doesn't exclude any other form of liability based on general tort. But the law also has a specific procedural standing for NGOs and trade unions, which of course only in the case where you would rely your claim on general tort law. So a first assessment. So I think the first thing that was interesting, and of course should not have surprised anyone, that the law really placed human rights and environmental due diligence on the agenda of German businesses and industries. Up until that moment, up until June 21, some German companies were doing this, some of them because they believed in it, others because they thought it was sort of good business. Most of them were not doing it. Most of them were not interested in it. That changed dramatically, of course, with the entry into force of the law. And of course, now some companies will actually engage in some substantive compliance. We see that, specifically those who've done it before, but others are pulled along. Of course, again, that should not surprise anyone. There's also significant number of companies just exercising box ticking. Right? This is what you would expect from companies who do not believe in this, would say, well, just another law, just another red tape, just another thing we have to do. Let's see whether we can find someone who can say no, who can't say no, and just put him in the office and let him fill out all these questionnaires. Now, what's interesting is that the fact that it only applied to large companies was an important element in the political compromise, but and many have said that it, of course, also has an effect on small and medium enterprises because of the way supply chains are structured, specifically also in the German economy. If you think about one important element of the German economy, which is, of course, the automotive sector, there are a large number of German companies which technically do not fall into the realm of the law, but which are nevertheless so closely linked to the supply chains of the automotive sector that they will be affected by the law anyway. One fun fact is, I usually jokingly say that up until sort of the beginning of 21, there was about a handful of people in Germany who actually knew how to spell business and human rights. That changed dramatically. Now there seems to be no major law firm which does not have dozens of experts in the field. Some of them are, well, most of them are not real experts. Some of them became experts overnight. And so, of course, this is quite a new business model also for German law firms. We have to see what the agency makes out of its competences. That's still out there. I mean, they started this year. It's too early to tell. I mean, some say, oh, it's just a small agency and it's in the Ministry of Economics. So what can we expect? Others say, let's wait and see. I'm more on the let's wait and see side. NGOs will monitor this. There are already the first complaints lodged with the agency, because you can lodge complaints with the agency. So we'll see how that goes. So the EU directive. Now, as I said, Beata asked me to speak about the German law, and I thought this is not going to be complete if I don't speak about the EU directive. And I don't know whether this is, see, the unfair thing is you put me on the spot at the very moment when the European Parliament is voting. So they vote now. So those of you who are on Twitter, you are forgiven if you, for the next couple of minutes, do not follow the lecture, but rather try to find out what's going on there. So the EU directive, I think is of course something that we need to discuss here. The background really quickly is we did have some of these laws evolving in some member states. I mentioned France, the Netherlands, Germany. They are proposed in other EU member states. Since we are receiving some money from Norway, I should of course acknowledge also the Norwegian Transparency Act, even though it's not, Norway is not a member of the European Union. I think we need to consider the Norwegian law as part of the wider European legislative context here. There's been a civil society campaign. There was a European Parliament recommendation in March of 21, and then, of course, in March 22, the European Commission came out with its proposal. And those of you who are a bit familiar with the European lawmaking will know that it's always the Commission that comes up with the proposal. The Commission has the monopoly to propose a law. The Council already adopted its position in December of last year, and now the European Parliament is expected to come up with its position. So they vote on it, but of course, that's not the end of the story. It's actually the beginning of the negotiations now, right? So the European Parliament needs to come up with its position. There was some last-minute sort of lobbying on the side of the conservative fraction, and so we'll have to see whether the report that was produced by the Committee on Legal Affairs, which is the committee in charge, whether that report will actually be adopted. The next step will be what is called in Brussels the trilogues, and some of us who are more familiar with the European legislative setting know that this is sort of the mystery chamber of European lawmaking. So this is when the two co-legislators and the Commission meet in negotiations and come up with a compromise. When will that happen? Difficult to say. My estimation would be it's probably, if it's going to happen, it's going to happen before June next year, because that's when there will be elections to the European Parliament. And the second half of June, the second half of 24, there's a bit of a challenging issue when it comes to the Council presidency. So we're not entirely sure whether the order that is presumed by the treaties will actually be kept. But even if it will be kept, the presidency is probably not going to be a presidency that brings this project forward. It's going to be Hungary. So for those who are wondering what I'm talking about. So my estimation would be, unless there are some real surprises in the legislative process, which I do not foresee, I cannot see right now, I would estimate that we have probably a directive by the end of this year or the beginning of next year. That means, of course, it's a directive. It has to be implemented into the domestic law of the member states. Member states typically have 2 years. So you can do your math. By 2027, legally, at least, all European member states should have the directive implemented. So what's in there, many of you will know this, of course, it covers large companies, in quotation mark, more than 500 employees. That's the Commission proposal. So we have no idea whether that's going to be the final directive. Quite possible that all of this changes. Smaller companies in specific risk areas, not just companies incorporated in EU member states, but also companies operating on the EU market. That's what they call the Brussels effect, right? So when you are operating, even if you're not incorporated, even if you do not have a secondary seat in the European Union, but if you're offering goods and services on the European market, you're covered by the directive. I'm pretty sure that that's going to stay. Detailed requirements of corporate due diligence, not going to go into the details here. Human rights and environmental obligations. It also mentions climate change. It took the climate change out of the due diligence. That's a little bit of a interesting, strange, unfortunate development. We'll see where this is going. It has a focus on civil liability, so it requires the member states to allow civil liability based on this law, but it also focuses on administrative enforcement and sanctions. So, impact on Central Eastern Europe and Central Asia. And Olena already said, I think it's important when we think about this to really distinguish between countries. And here I want to say that, of course, countries which are members of the European Union of the region will to a certain extent also be influenced by the German law, but the major influence will be the directive, right? So I would hope that in all capitals, people pay very close attention, not just in the capitals, but everywhere, because as Olena was rightly saying, this is something that has to be implemented by experts, by legislators, by companies, by NGOs, by lawyers from the countries. Because this being a directive, it means that each state, each member state can implement this in their own way. Now, the German lawmaker will probably change the supply chain law. The French lawmaker will change the French law. But we have no idea whether other countries will also adopt single due diligence laws or whether they will incorporate this into their corporate code or some other law or whatever. So member states are free in the means as long as they implement the directive. So of course, so they need to change and adopt national laws, but of course, that means that many companies will be subject to the direct obligations because they operate in these countries. Now, I would also say, even though I see an obligation in the member states and in the countries in the region, I also see the requirement of the EU institutions to actually engage in capacity building, specifically for the accession countries. You see that on this slide, I put EU member states and accession countries in one group. Of course, there are accession countries where at least my estimation would be that the accession process is not going to finish in the next couple of years, but is more process of maybe the next decade or so. But you know that as an accession country, you need to adopt what's called the acquis communautaire, basically all the laws that the EU has adopted. So at the end of the day, the accession countries will also have to implement this. This will, of course, have an indirect effect on other countries. And here's just a question that I'm not able to answer because I'm not an expert on many of these agreements, but many of the other countries in the regions have association or free trade agreements with the European Union. And so this is definitely something that can be integrated into the free trade agreements. We see already some of these free trade agreements with other countries in the European Union where this issue is coming up. It's actually, I was just two months ago, I was in Latin America and I had a consultation in the Chilean foreign ministry, and Chile is now renegotiating the free trade agreement with the EU. And this is precisely a topic that they discuss, and they wonder whether this is something that they should put into this agreement as well. What about companies? Now, of course, if you are a direct supplier of a German company in Poland, in wherever, then of course you will be subject to the human rights and environmental risk assessment, because that's what the German company will ask you to do, or is required to ask you to do. And that, of course, is an effect that may be handed down the supply chain. So even if you're not the direct supplier, but the second or third tier supplier, it's quite possible that these companies will feel these effects. Now, of course, a big danger or question or uncertainty is always, will that mean that we will see a significant restructuring of supply chains? Will companies, because they are no longer sure about human rights risk in certain countries, will they disengage? Of course, it's a little bit too early to tell, but we haven't seen any significant disengagement based on earlier laws. At least there's no empirical evidence concerning significant disengagement based on the French law, on other laws. There's one story in, I don't know whether some of you may have followed, there's one story of one German company that because of the law has disengaged from, I think it's DR Congo or the Central African Republic, I forgot which one. If you research the details of the case, you find that this is just propaganda because they were about to disengage anyway. It's a very, very small part of their business. So they just use this. They didn't like the law to begin with. And they just said, see, now we have to go back, right? It's not entirely true. So I would encourage anyone, also those doing case studies, if you hear this, really sort of do some empirical work and see whether there's really a real case of disengagement. Of course, if the suppliers actively oppose any form of risk management or risk assessment, then it's possible that there's going to be disengagement. I think the risk can be reduced if the countries themselves support these activities, either through national action plans or through legislation. Of course, there's also a potential for Central Eastern European and Central Asian countries in the context of what is sort of globally now called the de-risking strategy of many companies. At the end of the day, I think the question that we will all, or that sort of is the big question, is whether these laws actually sort of lead towards different business models, leads towards more sustainable and human rights friendly products, production cycles, also in the context of just transition. I think that's the ultimate question that we need to ask. And let me conclude, therefore, I think these laws can contribute to that kind of change. It can contribute to an effective implementation. And that effect may also reach beyond the companies that are directly subject to the legislation. And that, of course, then raises the question, well, isn't this just an imposition of Western standards on businesses and societies in other parts of the world? This is the decolonization or the neo-colonialist argument, then again, the danger of disengagement. My argument, my reaction to that would always be, this is not about Western values. This is about international human rights obligations that all countries in the world have. If that's the basis, well, then you can say human rights as such are a neo-colonial project, but that's a different debate we're having then, right? So, but if the basis is human rights obligations of all states, I think the argument about Western values collapses rather quickly. There is an increasing critique now about the law, the adoption of these laws without stakeholder consultation from affected communities and countries. I think that is a very valid critique. And I would hope that maybe also in the process of both the adoption of the law in the EU context, but also in other countries, that can be rectified. Because when you look at the legislative process in Germany, there were experts in expert hearings, but they were all German lawyers, right? So no one asked anyone from the affected countries and communities what they thought. So, and here's, of course, you ask a professor of law, a German shareholder, right? So you need to get some theory at the very, very end. So the way I look at this is that these laws are an element, are part of what I consider an emerging transnational and pluralist normative framework. Transnational, because we're not just looking at certain types of legal instruments. We're looking at domestic laws, EU law, we're looking at international treaties, we're looking at soft laws, OECD guidelines, we'll hear about more today. And we also look at corporate codes of conduct. It's pluralist because these legal instruments exist next to each other. There's no clear hierarchy. There's no sort of everything follows one model. So if you are into legal pluralism, I think that's really sort of the framework in which these laws can be discussed. But of course, the ultimate question, and that's not a question for lawyers to answer, certainly not for legal academics, is whether these laws contribute to fairer globalization. And I'll leave you with that question. And thank you very much for your attention.
Thank you very much, Markus. And I knew that you will be an excellent speaker, so no surprise on this one. I understand that we do have some questions online, but perhaps before I kind of ask Kośla to read them, I just wanted to ask if there are any questions in the room right now. Mark?
Thank you very much. And thank you very much, Professor. That was a spectacularly concise and clear summary of very difficult topics. The whole world is watching Germany.
Oh, no.
And can I call it BAFA or BAFA?
Yeah.
The agency that is implementing the law and the 60 to 70 human rights professionals there. And so far, no one knows really how they'll enforce, right?
Yeah.
What will we first see as a sign of their attitude? Do you think it'll be, I'll ask you to predict, if I may, will it be response to a complaint? Will it be guidance that they give to companies? How will we see their really their attitude towards enforcing this very important law?
Yeah. So we already see they've already adopted 3 guidances, partly concerning the reporting, but also partly concerning sort of how they understand certain elements of the law. So these guidances are, of course, not legally binding, but of course, they're an indication, and they're an important indication for the businesses of what the agency will do. They've also come up with sort of the first sort of framework of how companies should report to them. And my guess is that half of them, or many of them, hope that they will have a quiet first year in which they just gather the first rounds of reports and then see what they do with this. The other half is probably hoping for complaints from NGOs. Not NGOs, but affected stakeholders. And they have, you may have seen this, there have already been, the first publicly known complaint is a complaint against 2 companies for not joining the successor of the Bangladesh Accord. Now, I think that's quite an interesting case because it's a very clear-cut, complaint saying, in order to fulfill your due diligence requirements, you need to sign this accord. That's the idea. They will, legally, the BAFA is not obliged to react to that. Legally, they can do nothing or do something, and then actually the complainant can sue BAFA. That's the interesting thing. So probably in a couple of years, we're going to see some business and human rights litigation in Germany, not against companies, but against BAFA for not doing enough. That's possible that that's going to happen. Now, other than that, it will depend a lot also on the political leadership. You may know that our Minister of Economics is currently doing other things. Firstly, trying to get us away from Russian oil. He managed to do that. And now, of course, since Germans still want to be warm in the winter, trying to find other energy sources. I haven't seen a lot of sort of political guidance from the ministry in that direction, but that may come because the ministry is in the hand of the Green political party and they were very much in favor of the law. So they're watching this also very closely. So my guess is, yes, we will see some guidance, but it's quite possible that some of these cases will evolve rather quickly and then we will know.
Thank you, Professor. Oh, sorry, it's not working. It was really, really inspiring. I heard 2 main things that I'm just kind of staying in my head. One is what will be the support for all the medium and the small and medium enterprises, and not only in Germany, but outside Germany, because I do understand there will be an impact. And secondly, it's a question to you, it's a question to everyone in the room. What I've heard is stakeholder engagement early in the process. We know it's a really good word, but how do we do it earlier when all our states will start implementing this law? So can we think of ways to really work towards this? Thank you very much.
Yes, so the BAFA also has as a statutory obligation to support corporations, to support businesses, specifically also small and medium enterprises. there already was some support for these enterprises from the federal government. My expectation would be is that they will sort of increase this support. When it comes, of course, this is companies in Germany. When it comes to companies abroad, there are, of course, I mean, everyone can address the help desks of the federal government. There's a lot that I think needs to be done also by the chambers of commerce. There are also chambers of commerce, German chambers of commerce abroad. So I see a role there, but that really hasn't taken off the ground yet. So I think that's still something that needs to be explored. Now, regarding stakeholder engagement, I mean, to me, that's really the tough question right now. I think since this is my personal view. Since there's no clear model, I think someone should just start with something. So if in the context of the legislative process now, after the parliament voted on its position, the parliament or someone in Brussels just says, okay, now we are inviting someone. We are both reaching out to states, but also non-state actors, and just start listening. And maybe we're listening to the wrong stakeholders, or maybe we're not doing enough. Probably we won't do enough at the beginning, but since we haven't been doing anything yet, we should start now. And I think the same is true with member states. So I do not see why a member state implementing the due diligence directive should not say, well, in the process of implementing, we are trying to engage other stakeholders as well. And then I think in the years to come, there will be some best practice that is evolving.
Dear Professor, thank you for your presentation. I have a question about German law. So the law applies to companies with 3,000 or more employees, 1,000 next year. I wonder, is the criterion optimal? Because in modern world, the company doesn't need to have numerous workforce to be influential and to infringe on human rights. The company may have, let's say, 800 employees and still do harm. Maybe other criteria like turnover would be more appropriate. What's your opinion?
Yes, thank you very much. So this is, of course, an important question. There's no explanation for this threshold, but it's a political compromise. So the threshold of 3,000 and 1,000 doesn't exist anywhere in German law. And this is why we don't even know how many companies are there. I mean, it's not part of corporate law. It's not part of anything, right? I mean, it's not even part of the non-financial reporting obligations, which is for smaller companies, right? This is what two colleagues in mine and I proposed in the running up to the law, that we should link it to that number, because at least those companies have been reporting on something, so they should at least know what it is. Whether turnover would be a better approach, I'm not entirely sure. I mean, for me, the ideal approach would be to say, well, the guiding principles talk about every business. So that should be the starting point. Now, and we can sort of play around with the size and the leverage and the importance of companies when it comes to actual implementing obligations. Yeah, but of course, that's an academic thinking. It's likely that we'll see what comes out of Brussels, but if the number there is lower, Commission proposed 500, Parliament even 250. So there's talk that the Council will settle for 1,000. We'll see, right? Yeah, but you're absolutely right. It's a political, and I find it interesting because it's also it doesn't clarify much for businesses either, because some will fall in it, some will fall out of it, and they go like, well, we have 1,100, our competitor has 900. Why is the difference, right?
Thank you. And the last question from the room, and then we'll have 2 questions online. And just to say that the voting in the European Parliament is currently going on.
It's still going on. Okay, good. Oh.
Thank you very much. And thank you for trying to get everything into this short presentation. My question is, I have 2 questions regarding 2 pieces of puzzle of the EU Green Deal that is not included in the presentation. So the first thing is the interaction between CSRD, SFDR, EU taxonomy. because under SFDR, we have an obligation of due diligence of investment firms and other institutions to conduct due diligence with respect to investments, and we have this do not significantly harm criterion. Under taxonomy, we have minimum safeguards, and under CSRD, we'll need to report on the due diligence process in the companies. So we have different regulations that interact, and they will also interact with the CSDDD, which scoped out part of the entities that will be covered by other obligations. So my first question is whether all those obligations will merge into one system that so we have like indirect, I don't know, influence of CSDDD on how this process should be done under all those other regulations. And my second question is about the consumers and their impact on CSDD implementation, because we have all those green claims directive and increasing the role of consumers in green transition. So we'll also have the green claims and sustainability claims certified, or maybe not. So do you think that we'll have like this evolution of CSDDD into a certification of various aspects? So like outsourcing of obligation of the due diligence process onto certificating entities. Thank you.
Thank you. Yes, I mean, you point to, of course, an extremely important aspect. I mean, the benefit of being an academic is that sometimes you can lay back and just see the world is very complicated. Let's just wait and see what happens, right? This is, of course, not the benefit that any practitioner or any business person has. But you point to, of course, different legal or quasi-legal developments which come from very different corners, right? So the non-financial reporting directive comes from a different strand, the taxonomy comes again from a different strand, and the due diligence directive is yet again coming from a different strand. Now, legal pluralism would say that all these systems can exist next to each other, and what we will see is whether there's going to be emergence or whether one of these instruments is going to become sort of the leading instrument. Now, this is a very frustrating answer for any practitioner or for any businesses, but that's the best answer I can give. It's exactly as you describe it. There may be overlaps, there may be even contradictions, but this is often how legislative process is happening, because at the end of the day, lawmaking is not a rational process, it's a political process. And so, yeah, I mean, this is the best I can say. With regard to the role of the consumers, yes, that's interesting to see. You know that the earlier laws, specifically the transparency laws, placed a lot of hope into the power of a consumer. That hope was disappointed. So maybe in the next round will be that consumers will actually claim more that, you know, if you say this is human rights friendly, right, or labor law friendly, or whatever, that we can rely on that. There is definitely a trend towards certification. I mean, that's very clear. So to me, actually, I think the next legislative step would be actually to come up with a legislation for certification and for some standard setting. We have that in other parts of the economy as well when it comes to product safety. So I think we need that in this field as well.
Thank you very much. And we'll have 2 questions from our online audience. And after that, we'll stop for a break. I am aware that we've got a bit of delay. So we'll start after the break at 11:50.
Okay, the first question is concerning the supply chain. Is there any difference between requirements of CSDDD and ESRS S2, that is the workers in the value chain?
Sorry, could you read it again? Is there a difference between
the requirements of CSDDD and ESRS S2, that is workers in the value chain?
That's a good question. I wouldn't know whether there is any difference because they rely to the same workers' rights standards. I mean, they refer to the same human rights instruments and the same labor law standards. So I'd be surprised if there's a difference. I mean, I would have to think about this more, whether there are some, when it comes to due diligence, but I would say probably not. But I'm looking into the room where they are the real experts. Someone seems to know the answer.
Well,
I don't know if I can ask, but I know it's ECRS, which refer to workers in the supply chain. Simply, there is a very specific formulation, what should be done, how it should be measured. So I think it is rather a tool to implement the law. So this is my
okay, good. Okay, so thank you very much. I didn't know that, but that the answer would be the standard is the same, but maybe the tools and there are more specific tools in various different instruments. Yeah.
Yes, and my guess would be like they all should refer basically back to what is the standard set out in the UN guiding principles. Sure. But obviously, once the ESRS were developed, they were kind of developed to help companies implement CSRD and taxonomy. And yeah. And we don't know what will be the final shape of the CSDDD, what will be the value scope, how they will define it. So it's still a bit of we are still on the very uncertain ground, I would say.
And then Baliniam Ishkan, I hope I'm pronouncing the name correctly, is saying, thank you very much, Professor Krajewski. My question is, I just wanted to know your thought on whether EU directive and any other Western legislation on due diligence can actually have a positive impact on human rights violations occurring in poor developing countries. Thank you.
Yes, thank you. That's the $1 million or I don't know, 10 billion złotych question. I'm an optimist. And I believe that what we're doing here with these laws is basically we're sending signals to companies. And I think what we can see is that some companies are changing their models. And therefore, I think they have a positive impact. Now, if the threshold, the measurement is in 5 years down the road, will there be no more child labor in DR Congo? If that's your approach, then I guarantee you 100% you're going to be disappointed. There may even be more child labor because, of course, these are so complex issues. But I think at the end of the day, these laws can have a positive impact. But of course, they're not the only instrument, right? So we should not say, as long as we have all these instruments, everything is fine. But yes, I think they can have a positive impact.
After even the extended time. And I would like to start by introducing Annabel Short, who is a research fellow now with the Institute for Human Rights and Business, which is one of the oldest institutions, organizations working on business and human rights, I guess. Annabel has tackled a number of issues concerning business and human rights in her career, but the most recent project or area in which she's working on is basically the one concerning built environment and just transition. And today she'll talk to us about the reimagining the built environment for rights respecting green transition. And I've asked her to, but basically when I was talking to Annabel about what we need, I was just kind of stressing that I think we need a bit of an inspiration. And sorry to put no pressure, but basically, I think as people have probably little or none issues with our health and so on, we are still relatively young and so on. And I don't think we kind of sometimes realize how difficult the environment in which we work and function can be for people with different difficulties or just different needs simply. And that's what Annabel will be talking to us about today. Thanks.
Great. Thank you, Beata. Is this working fine? Yeah. Okay. First of all, just really honored to be here. I think Olena and Beata, like what you've done in terms of the program, and then I know what the impact will be sort of going forwards. I think we can't predict all the things that will come out of it, but it already seems pretty incredible what you've pulled off. So thank you for inviting me here today. I thought I would, so I've worked for many years on human rights and business issues, right from pretty much the early UN guiding principles days. And I've also worked locally where I now live in New York City. And I always keep holding on to that Eleanor Roosevelt quote around where do human rights begin after all? They begin close to home, in the places where we live, in the places where we work. And while I try to see a through thread through my career, that's often where I land, is linking the very lived realities in places and how human rights are experienced in specific places with the people who impact how those places affect people's lives, who may be investors, they may be governments at the other side of the world even. So what are the local realities and then the international processes that are affecting how human rights are lived close to home? Briefly, what the hell I mean by built environment. So I had also worked, through my time on business and human rights on construction industry issues. Some of my local work in New York City was around a campaign to reduce emissions from buildings, but I hadn't actually heard of the phrase built environment until I started developing this project with the Institute for Human Rights and Business. But it's very well recognized within the field of people who work in it. Essentially, we're talking about buildings, infrastructure that then supports those buildings, and the places that are in between them. So essentially human-made spaces. And it's also good to think about, okay, those physical spaces. So if you start imagining, where do you live? What's the town? What's the city? But then also the supply chains, that feed into building it. These are just a few examples as to why I've become very passionate about the built environment. I will definitely bring some inspiration, I hope, but that's not to say there's not a huge amount of challenges. And that's partly, these intersecting challenges are partly why I think it's so important to be thinking about both environmental and climate action, human rights action, and how those join up in the context of the built environment. One is the huge climate footprint. So when people think, okay, we need to transition off fossil fuels, we need to switch to electric vehicles, etc. It's also important to think, where is most of this energy used? So there's an important transition in terms of building energy sources within buildings, energy efficiency within buildings, etc. That stat in the middle really drives it home for me. I think a lot of the approach that I bring and think is important is around follow the money. If we think human rights are checks and balances and claims on power, whereas does a lot of the power lie? It lies where the money is. So 60% of the world's assets are in real estate. That breaks down apparently as 3/4 is residential, which I actually find quite surprising. 13% of that is commercial and 12% is agricultural. So just a huge amount of the way that the money people describe wealth. We can debate what we want to call wealth and value, but it's locked up in terms of land and how it's used. Just to touch on two other pieces around the human rights dimensions. This program is cross-cutting across the whole range of human rights, but the ones that are most frequently elevated and that encompass so many of the others are the right to adequate housing, and recognizing that in pretty much any context, the right to an adequate home, an affordable home, a safe place to live, a decent place to live, a warm enough or cold enough place to live in a changing climate is out of reach for many people. And there are also almost, I think, 1/6 of the world population living in informal settlements. Also on the workers' rights side, obviously huge numbers of people working in the construction industries, both building places and then also through the building materials supply chains. So that's a bit on the why. The approach that the program takes has developed this framework, which there's a a one-sider which summarizes it that I've left down there, and then you can download the full thing for anyone who's interested as a sort of interactive spreadsheet. My dream is one day that will be a digital platform, but at the moment it's a spreadsheet for those who like spreadsheets. And the idea is let's translate international human rights standards and the Sustainable Development Goals into the context of decision-making around the built environment life cycle. And I think earlier, the point of early action was lifted up. So we're working to apply this both at the context of specific projects and in policy advocacy. So on the project side, for example, I feel like the sort of campaign mantra just needs to be early action, like pause at the beginning of the project, invest time, think about what its actual outcomes are supposed to be, recognize that a building project or an infrastructure project ideally will be there for many years to come. So take action at the early stage to think around who's impacted, how can those risks be mitigated, but also how can positive outcomes of this project actually be maximized. So the spreadsheet that sits behind this for each stage of the life cycle has a vision for what it would look like to get this right, some guiding questions for practical action, and cross-references to both the relevant international human rights standards and SDGs, and then examples of people who are working to get this right. I won't go into detail on each stage. I think just to lift up some of the really crucial issues on the land side, the fundamental issues around, well, who has access to ownership, obviously, and who controls the ways in which land is used, spatial dimensions within cities, and then obviously the multiple issues around due process and acquisition for land, so avoiding forced evictions, etc. Planning and finance, we grappled for a while, should those be two separate stages, but they really are kind of, I feel like, the elephant in the room in terms of what defines everything else that follows. Is it just finance dictating the shots? Does planning take account of human rights risks and local residents, etc.? And corruption is one of the major human rights issues there. I think if we think about the Odebrecht scandal, for example, that involved construction projects throughout Latin America, actually led to the toppling of governments, even down to the latest the earthquake recently in Turkey and Syria, for example. And I think the excessive loss of life there, one of the underpinning reasons was that the building codes had been diluted, and there'd been kickbacks to politicians to not enforce those building codes, which lead to buildings that can collapse just like that when an earthquake comes through. So really sort of granular and specific, and in some ways boring things like building codes and their enforcement are so important for the realization of the right to life, and also for the quality of buildings that people live in. Access to public space, also a key one. On the design side, Beata was mentioning sort of the ways in which places are designed. There's the story that often goes out there around many cities and places being designed for a 6-foot-tall white guy, because of the sort of original engineers and architects that came up with the ideas of how places should be designed. What does that type of design mean for women? What does it mean for minorities? What does it mean for people with disabilities? So a huge role for the design and architecture industries to really be thinking about what are our responsibilities for human rights. And interesting thing with the role of architects, I think, is that they're in this sort of intermediary role. One, they have choices around who are their end clients, who do they want to be building for? And then in designing their buildings, are they going to create space and time to be thinking about the end users in all their diversity, to be thinking about the local communities and in some ways advocating up to their clients? However, the way the Institute landed on this program was hearing from construction and architecture companies saying it's all very well to say we have these responsibilities and we'd love to respect human rights throughout our operations, but the way the industry is structured is we're pretty much beholden to our clients and our clients' needs. And it's also an industry with complex supply chains, short margins, supposedly fast timelines, where corners get cut, and therefore it kind of squeezes the ability of companies in those industries to respect human rights. I touched on construction workers as well, but just to highlight also, yeah, the materials side is where, I mean, multiple stories of human rights impact through the construction material supply chain. One very specific example is brick making outside Phnom Penh in Cambodia, where there are really interesting sort of, interesting and hard climate and human rights and modern slavery intersections, in that farmers are being pushed off their land as the climate changes, work on the outskirts of the city in brick making to build these high-rise apartment buildings that they're never going to dream of affording, and lots of exploitation of examples of child and forced labor in those brick factories. So that's really sort of at the intersection of climate crisis and housing and affordability and difference within cities. On the management and use side, just to highlight, there's obviously the issues of security forces working for infrastructure and building projects, security forces for buildings, but also the big rise in digital cities and the use of technology in cities. So we've recently, with support of UNDP Asia Pacific, going to be bringing out a smart cities toolkit on tech companies that are increasingly bidding with cities to roll out smart city strategies to improve efficiency, etc. But there's often a covert surveillance role or ways in which necessary security measures, but can then be harnessed to discriminate against certain populations. So real risks embedded in terms of how technology rolls out in the built environment. And again, a kind of business model dynamic that you see often, which is, here is the product, here is our solution. It gets pitched to cities, but it's pretty disconnected from what the actual infrastructure and real important needs are at that city level. This was, in a way, an illustrative point around bringing together, probably a couple of years ago now, it was when everyone was very much only on Zoom, several different UN rapporteurs to discuss the way in which the built environment impacts the various rights that they work on. So there was the UN rapporteur on the right to housing, a UN rapporteur on the right for people with disabilities, on the right to privacy, and the right to health from South Africa, and thinking about both the physical and mental health dimensions of the built environment. And for me, it was just sort of very interesting in that they could all see, but hadn't yet quite enough come from this lens of thinking about the importance of decision-making and planning in the built environment impacting the various rights they work on. UN Rapporteur on the Right to Housing has actually just brought out a really good new report on climate change, where we pushed and engaged and encouraged him to include specific recommendations for businesses as well as for governments. And so he breaks down for investors in housing and for architects and engineers, what are their responsibilities with respect to ensuring the right to housing in the age of the climate crisis and climate mitigation. Won't spend a huge amount of time on this infographic either, but it's a way just to get people's minds thinking about leverage points for human rights. So we've talked a bit about, a lot about, due diligence requirements for companies thinking through their operations. What the framework does here is trying to unpack, like, what are the ways in which human rights risks may be embedded in terms of contracting requirements. For example, if cost and budget, if cost and time are your only parameters, for example, when you're commissioning a big infrastructure project, you're kind of baking in abuses. So one of our sort of big goals with the project, in addition to the project side, is to think about how do you actually shift the way that some of these processes happen. So government procurement, there's a time at the moment when there's a lot of procurement coming through with climate goals. How do we ensure that there are social protections within those procurement measures as well? On the government side, a key dimension is also thinking about the respective duties of national governments, but also local governments. And so many of you probably know, like, the Office of the High Commissioner for Human Rights has elaborated detailed descriptions of how the international duties on human rights apply to local government administrations as well as national ones. And I think that dynamic is one that can look very different in different contexts. You have some states and cities that actually have a huge amount of legislative power and budgeting power, in which case harness that, let cities are close to their residents, towns are close to their residents. That's an enormous opportunity for advocating for human rights and saying, hey, city government, what are you doing about curbing abuses by these, the private waste industry is the case I worked on in New York, for example, or what are you doing to actually kind of put some checks and balances against very extractive real estate investment processes that are leading to big towers up in the city that are just parking people's money, for example. So a huge amount of opportunity to approach local level governments with human rights advocacy, while recognizing also, though, that municipal governments in many contexts are very cash strapped and don't have huge legislative powers. So there's a need there also to be kind of saying, oh, are there opportunities to be localizing rights and to be expanding those local powers? So yeah, that was just a segue around when I say governments, what kinds of governments we're talking about. And in the investor space, I think a key piece of the work has been really elaborating as investors are thinking about ESG, lifting up, well, what is the S? Not only what is the S, but then how does your investments around E impact the S? Just one specific example in the built environment is that a lot of investors will say, tick the box, we're investing in certified green buildings, and therefore our portfolio has gone green. And then we did some maps to look at, like, this was in the context of Europe, looking at where are all of these green buildings that all of this cash is flowing into. And you can probably imagine they're nearly all in the financial centers. And so just sort of elevating that as much as possible to say, when you think you're greening your portfolio, in some ways you're kind of embedding and digging, creating even deeper inequality along the lines where it exists today. How can that be changed? One is saying go beyond certifications. Two is broaden the type of building and place where that building is that can get certified as green. Deutsche Bank, it was interesting, I just saw yesterday, has just issued a piece around real estate and their role as a bank providing mortgages, etc. And it was encouraging, one, to see how they're acknowledging how they have a huge climate footprint. They even quantified it. They said, we're supporting and financing this amount of real estate with this size of climate footprint. And they also said that of their private clients, they had calculated, I would need to dig into how, that 2/3 they felt would be able to afford getting up to climate standards and retrofits, but 1/3 wouldn't. And at least they're out there and saying there's clearly this sort of, segment of the population that's obviously not going to be able to be, retrofitting and improving their houses. I think, okay, there's pause on those because I want to leave plenty of time for questions at the end. So, and one of the big projects that we recently got underway, so as I mentioned, the framework is used on 2 tracks, projects and policy level, but then those 2 columns, as it were, are supported by research and communications. And so this is a project that we're about halfway through, thinking about how are green financial flows into the built environment, how are green actions, both to reduce emissions from buildings, but also to strengthen resilience, impacting people. And it's pretty amazing, like how those questions haven't really been asked yet. So in each city, I was calling them deep dives, but I've rapidly realized that in 3 months, you can't do a deep dive. So it's been a huge lesson also in sort of action research, strategies, the approach you take, etc. But in each city for a 3-month period, a locally based researcher is asking the same types of questions for their specific local context. What are the climate risks in the built environment? What's being done about them? How are these impacting people? So the 2 that have just wrapped up, for example, in Lagos, the issue was, well, there's a lot of excitement about some big green, shiny climate plans and C40 cities and others who have their sort of climate plans for the city and commitments, but that rarely mention the 2/3 of the residents of Lagos who live in informal settlements. So that's a bit of a kind of, it's been touched on here too in terms of due diligence measures of that sort of external importation of solutions without really engaging the local populations. At the same time, great organizations on the ground, one called Spaces for Change, for example, which is thinking, you know, what we need to be doing is really like educating, inspiring, working with the next generation of architects and engineers in Lagos, harnessing the sort of design and tech excitement within the city to drive things in a better direction. And in Prague, in a nutshell, many of the findings, there was a lot of distrust, and that's something that plays out here very much too around EU, you know, green policies and funding, and people saying we can't access these benefits, particularly for low-income tenants. So a lot of the points there were around like communication. What does this mean, like for residents in the city, and access to support and benefits that are coming through. It was also a good opportunity, for example, to be lifting up and joining the dots between those housing issues and worker exploitation. So there's a lot of Ukrainian, Bulgarian, Romanian workers within Prague working on construction sites, none of the benefits of unionized construction workers, and you know, crazy exploitation in terms of passport confiscation and bad housing and unpaid wages and those kinds of things. So if you're interested in what's coming out from those cities, you know, check out the IHRB site and follow along. And while the research is being done in those specific cities, the idea is that then we can bounce up to have more regional conversations. So for example, the 4 that are within Europe, Lisbon having just been completed, the idea is that then the insights will feed into, hey, EU Green Deal, hey, EU due diligence processes, how are these playing out sort of on the ground in certain urban contexts? And what are the ways that within green finance and action, we can strengthen the human rights dimensions? So I'm just putting those out there as, yeah, 2 challenges, but also questions I feel like for you, maybe in the Q&A, like, does any of this resonate? Are there contexts in your own specific countries or places where you see some of these risks around like real estate buildings construction? And are there ways that we can all be getting more creative to apply the corporate responsibility to respect to the industries in those sectors? And then similarly, ways to be sort of expanding or thinking about the leverage points that subnational governments have. I think the US has actually even now got a secretary of, not quite secretary of state, but, you know, senior representative for subnational diplomacy, which is a pretty interesting indicator, I feel like, of saying that cities and state governments now want to start having their own diplomatic ties, often washing their hands of what's going on at the national level and saying, we want to move in a different direction. Let's get together to figure this out. So I hope that provided a bit of inspiration as well as a big challenge and some food for thought. And I would love to hear any questions, but also examples of where you've seen specific cases involving these industries.
Thank you very much, Annabel, for this intro. I mean, it was inspiring for me. And perhaps just a comment before I give the floor to questions, that we start to get asked by companies who are the real estate companies, who are starting to get questions from the companies who are renting the space from them. So they are getting, like, particularly real estate companies who are administering like shopping centers and so on, are starting to get questions from their customers about are they actually starting to comply with some of the legislations that is currently being introduced. So kind of the taxonomy flies high, CSRD flies high, and so on. So we kind of see this impact already getting there. It's slightly different, what you said, kind of in terms of the motivation and so on, but I mean,
wherever the motivation comes, we take it.
It's good.
Yeah.
Exactly. So would any of you have questions? Yep.
Thank you very much. A very inspiring and very broad subject.
Yes.
And I'm particularly grateful for bringing in one of the actors that are generally missing in the discussion about human rights and business. It means public sector, and especially municipalities and local governments.
Yep.
Because, okay, so my question is, whether have you come across a situation when business try to somehow remedy, or I don't know, do something with problems that municipalities did at the beginning of the investment process? I mean, planning or organizing, because, you know, it's setting the frame, and the business should somehow interact with this frame that may, in the beginning, cause breaches of human rights.
I think that brilliant question. And yeah, as you say, it's a complex field, and that's why often I find like jumping into one specific piece within it and then being cognizant of the wider framework is important, because I have had people sometimes see the framework like it's confronting, like where do you begin? And it's like start here, and then you can kind of see where the other connections are. Two examples, I suppose, on the planning side. And then a reflection is Belfast and Johannesburg. So I think those are both cities, for example, where you've had like inherently discriminatory policies being baked into the fabric of the city. In the US, actually, also in terms of roads that have segregated Black communities from white communities, and that those experiences are still played out today. So Johannesburg, it was apartheid. In Belfast, it was along religious lines. And so there are groups now of like planners, engineers, and others who, one, through their own sort of work on projects, can try to start addressing some of those designs through projects, but also through their own kind of visioning, even if those ideas don't always come through. I think there's often a huge amount of sort of visioning and inspiration that can come from those industries. One, to kind of try and undo and unravel some of those systemic injustices that are baked into the built environment. At the same time, I think that's where really always thinking about state duty to protect and corporate responsibility to respect in any context, like which is sort of leading to push the other. Because you'll also have plenty of time, maybe on the smart cities is another dynamic where you'll have, you know, solutions that really don't address what the municipalities are sort of needing, and ideally people within them may want to be doing. So yeah, in each case, it's sort of thinking who's moving in the right direction and trying to like support them in order to influence the other, if that makes sense.
Rohia, and then we have Akaki.
Thank you very much for the interesting presentation. I have a question. Last year, I was conducting a seminar for the representatives of municipalities of 5 countries. And this was a seminar organized by Swedish International Center for Local Democracy.
Great.
And the representatives of municipalities from countries like Albania, Macedonia, Georgia, Turkey, they were participating in the seminar, and there were cases, very interesting cases about constructions and Georgia and Turkey, they both represented cases when the government received a proposal from the business to build a certain factory, for example, or to build a certain plant in the territory of municipality, and municipality gave its opinion about it, and actually which was not so supportive about this because of its impact to the environment, because of the impact to the health of population. But in the end, despite the opinion of the municipality and despite the opinion of the stakeholders of the community, the government still continued with supported the decision of the business. And because of the profit and
the tax rate or the income from taxes.
Yes, the income, exactly. Yeah. So I just wonder if you have any best practices or any other good examples where the community or the municipality could win in this situation, and what can be done to improve the real impact of the municipality and stakeholders in adapting decisions like this, which impact their life actually. Yeah. Thank you.
Totally. And I think that goes to that intersection point I highlighted earlier, and on the infographic, when you think of government and finance and saying that's the elephant in the room, like it really is like who's wanting to invest and why, like really, often really does call the shots. I think I was really inspired the last 2 days in Łódź, like 2 hours from here. So former textile town, and then the textile industry just stopped after the wall came down, and then there was much more kind of international trade and competition, and so literally like from one day to the next, the industry that the town depended on ended, and so there was a big moment of decline and joblessness and all of the association issues that come with that. And I think in that case it seems like, not without challenges, but that the city has worked very hard to kind of think, how do we draw on that former industrial tradition to think about the regeneration and change of cities? And how do we get private investment? How do we shape that private investment to our benefit and needs locally? So they've had investments in like revitalizing the old factories, turning them into new buildings. They've had a private investor totally transform the old power station into a conference center. I think maybe another 2 examples. I know the mayor of Freetown in Sierra Leone has apparently been very savvy about that as well, and kind of saying, we really need investment in this city, but I'm going to be assertive as possible about the agenda and how, like, yep, international finance, come in, build your things, but this is what we want you to build. But it's not easy. Like, I think you have to be a real fighter to make that happen. And there are many municipalities who don't have those fighters, or they don't have enough support. But I think that's maybe where also the networks of municipalities who at least like hear each other with those struggles, but then hopefully also share solutions come through. Medellin is the classic example that's always lifted up as well in Colombia, around sort of saying, how do we deal with a city that's had a real issue with violence and real segregation between the center and people who live in the informal settlements? Oh, let's build some shiny, internationally architect designed libraries at the top of the hills, and let's build cable cars. And then people, 1, want to go up to those libraries, and 2, the cable cars are a way that cuts like travel down for people who live in the settlements to get to work by like 2 hours. You're not sitting on a bus going down, the hill for like 2 hours to get to work. You go on a cable car. So the more of that kind of visionary thinking about like, what are the real issues within this city, and how can we solve it, and how do we get the money in to solve it, is what's needed, I think. Sorry, long answers.
No need for apologies.
Okay.
Thank you for your excellent presentation. My question is like very practical. Actually, this is a very challenging issue in Georgia, like especially building residential buildings, not only without some green areas, but you will see cities where like there is a residential building, and in front of this building there is another building, and even the sun you can't see the sun after next years when there is another building built. So this is a very problematic issue. And what would be your practical recommendation? For me personally, it affects me as well, and I want to be activist in this direction, and I want to raise my voice. I see that terrible things happen in this relation. So what would be your practical recommendations? How should I act? What kind of advocacy can I have, and what can be done to fight against this kind of huge problem? Thank you.
Yeah, wow. One idea that I have, that I don't know if there are, I'm sure there are people, because I'm based in the US now, I'm not immersed in everything that's going on in Europe, but a thought that I've had is about really recognizing that is a fundamental issue in so many cities, number one. And I think the Gezi Park protests in Istanbul were sort of almost, were initiated through the whole idea that this public park was going to make way for a mall. And yet through the pandemic, it became so clear, I think, that like green space, just seeing trees is like, one, it was a necessity for people to be able to just get out of where they're living, but also in terms of mental health benefits and the climate benefits. But I just saw the other day that I think with some of the regional level political shifts within Europe and upcoming elections, that within the EU Green Deal processes, the nature dimension of including access to nature within those is going to be scaled back. And yet one of the first things people say when you ask what do you enjoy or is important to you in your city is like green space. So maybe there's an opportunity to kind of, for a regional wide campaign of like, here is how it's playing out in all of our cities. And this should be a part of, you know, a part of where the regional investment is going and that governments can get behind. More locally, I'd say that's where I feel there's a lot of inspiration amongst like young architects. I don't know about in Georgia, but there's often a lot of the change comes from within young people in the profession who don't like the way things are being designed and then organize just to become like small groups, but then begin advocating. So definitely, I think an important area to be pushing and advocating on.
Hello, thank you very much for your presentation. I've got a practical question. Could you give us a tip or show methodology how to evaluate investment to co-finance or to finance it? We are an institution that gave the money, so we want to check is the investment is green, is it rights respect, is it environmental friendly? Could you show us some methodology to be useful for us to evaluate this investigation?
Yeah, I think that's really important in that, you know, there has, while there's been a lot more focus around like investing in ESG, then there are big issues around, you know, especially sort of pooled funds and where does the money actually go and what's actually within this portfolio and how do you trace it down? I'd say, I mean, it depends at what level you're investing, I guess, like whether you can actually kind of specifically ask companies directly that you're investing in and sort of trace down the line and ask smart questions is the way to go. Definitely engaging within the places and people where those companies are operating in as well as much as possible. But I know there's also anti-greenwashing measures that are underway. So yeah, let's exchange details and I can maybe share some like more specific frameworks and things like that around frameworks for trying to really ensure that portfolios are as green as people hope they are.
Thank you. And we've got Mark and Gosia wanted to ask the last question.
What the heck is the built environment? I think your work has answered that question for me over the years. I'm not asking it again, but I've been following it and I appreciate your answers to that. So at Nomagea, we've looked at the green transition and business and human rights. And obviously climate change and business human rights are twisted around each other in a way that you can't extract one from the other. And we have seen places in power generation, for example, in transportation, where the green transition goes one way, take cobalt, for example, and business human rights goes a contrary way.
Totally.
They pull away from each other. In the built environment, in your experience, do you see examples of that? And can you describe that for us?
Yes. And that's why I think this work of joining the dots is so key. So it's not we're saying human rights due diligence here and climate action there, because what you're doing here may be making this side harder, you know, so it's really trying to think about joined up policies and investments that combine the two, of which there's a lot more momentum, which is good. I mean, one example is that sort of green building certification investment dynamic, where that's where a lot of the green investment's going. But in some ways, if that's all you're doing, you're going to be further exacerbating risks around the right to housing. But another definitely is around the sort of huge material requirements for the electrification of buildings and of the energy grids that support them. So, you know, when you think, okay, 37% of the world's emissions, energy-related emissions, come from the building and then the operation of buildings. Think about the construction stage. Okay, you're going to get nice new green materials, but where are they coming from? But then importantly, if you're going to be switching grids and then the use within buildings to solar, wind, etc., where Xinjiang dimensions around the construction of solar panels, for example, I think a lot of organizations are doing, really important work that's sort of scrutinizing the supply chains for electrification and for decarbonization. And that, again, I'm just a sort of advocate for local, but I think there is quite a big movement to say, how do we actually source what we build with more locally, but then also kind of, localize energy supply chains as much as possible. And I think the Ukraine conflict has also been a reminder of that. I feel like in this situation, sort of there's this sense of, if earlier action had been taken to reduce dependency on gas supplies from one country, to localize energy supplies, people would be more resilient on so many different levels. And then that helps with cost spikes and things like that. So there's an interesting supply chain momentum, I feel like, underway. The US with the the Inflation Reduction Act, for example, and a big piece of that is saying, we've got to green the economy. Yep, we're going to use subsidies, like it or not. Europe saying, okay, we're going to do it too. And within that context and all of that money flowing, I think it's really critical to be saying, how is that done? Which companies are benefiting? What are their supply chains like? And how can it be used to kind of regenerate areas also of economies and of countries that have been left behind. So really thinking about that spatial dimension as well.
Annabel and Kośla.
As if we didn't have enough problems with human rights, I would like to ask a broader question, as we are taking up the space of other non-human beings in building sustainable cities. And we all want to live in the nature, but actually we are taking up the space of the nature, normally not thinking about what's happening to this nature. And I am just curious whether this dimension, which is complicating things even more, being taken up in the discussions at all, and how do you project in which direction it might go, taking from your experience? Thank you.
Great question, a really important one. I think it connects a bit to the point around like needing to lift up the importance of nature. I think the been human rights and legal wise have been interesting developments, around the rights of nature. I mean, and the Chilean constitution effort to try to include that, and it wasn't included, which I think is also an interesting kind of, that constitution was rejected in the end, which is an interesting sort of sense check as to where people are at in terms of how fast they want certain things to change. But rights of nature concept is growing. The right to a healthy environment was recognized by the UN in 2021 or 2022. So I think really harnessing that is key. And then in terms of two other elements around access to nature is, one is the sufficiency sort of movement. And I think some who are active in the Paris climate change negotiations and things have been lifting up how the more developed countries really need to think about sufficiency. And I would also argue sufficiency in terms of ownership in all countries, like, is it okay if some people own 4 houses? Is it okay if some people invest in a tower that remains empty? So really kind of exposing and thinking about how space is used to try and make more space for nature. Definitely, and the rise in nature-based solutions, which is encouraging, and saying that as cities build their resilience to climate change, let's not just build concrete walls, but that, revitalize oyster beds, mangroves, whatever kind of climate you live in, like actually making that. So I think on the city side and on the finance side, there's a lot of interest in that, which needs to be harnessed. And then just the last point to bring it back to human rights, though, is thinking, yes, let's sort of reinvest in nature and bring as much nature as possible into cities, but who has access to it? And that, often the places that get the most benefits from like new expansion of nature are the ones that maybe need it the least. So making sure we're always bringing that kind of human rights and environmental justice perspective to where those investments happen. To complicate it all at multiple levels. But I'm glad you asked that question, because I think that's also connected to the climate crisis. And if we're not thinking about biodiversity as well as climate in the spaces that we build, then there won't be a planet left for us to be talking about. So very important.
Thank you very much, Annabel, both for the presentation and for all the answers. And before I hand over to our next speaker, Ms. Jacqueline Kacprzak, who is from the representing Ministry of Development Funds and Regional Policy, and at the same time Polish OECD National Contact Point for Responsible Business Conduct. Just a quick logistical announcement. We will do the presentation and a bit of a workshop with Jacqueline will be the last part of today's morning. Then we'll break for lunch at around 1:30, 1:40, and then we'll have the official launch of the publication and presentations of case studies after the launch. So, and now without the further ado, I would like to ask Jacqueline to take over. And perhaps just a word of explanation. So the reason we've asked Polish NCP OECD to be with us today is simply because we've realized in the process of overseeing the case studies development that there are a number of questions and misunderstanding about which companies are covered, which companies are to be treated as multinational enterprise, and so on. And I hope Jacqueline will be able to explain it to us. So Jacqueline, over to you. I'm not sure whether you want to use this one, but I'll put the presentation on.
Thank you very much, Beata, and hello, everyone. It is very good, sorry, to see you all here coming to Warsaw, Poland, and some of you I know via different social media, and it is very glad. I'm very glad to see, for example, the Miss Dr. Olena Uvarova. It is first time when we could met just in person. And also, I would like thank organizers for inviting us for this event, and congratulate to Beata and her colleagues to choosing this particular university, because Vistula Group and Vistula University is one of the Polish universities who signed Declaration of Social Universities Responsibilities. This might be also interesting for you. We have in Poland almost 400 different types of universities, and 160 of them, they are today in the big group of the universities who signed this declaration of the university social responsibility. So congratulations to choose this responsible place for taking the conference. And also, we are very glad that we could have this chance to present to you our experience as the Polish NCP. What I would like to start is just the general information. Probably most of you are aware about the OECD guidelines for multinational enterprises, but I think it is good just to make some basis for the explanation how it is possible to bring the case to the NCP, just to be aware where we are, in which circumstances we are working. So the OECD guidelines for multinational enterprises is the oldest responsible business conduct international standard. As you know, the OECD is not using the CSR term or the ESG term, the most popular term nowadays, but the OECD is using the term RBC, which stands for the responsible business conduct. And the OECD guidelines for MNEs is the oldest general international standard, because as you see, it was adopted by the OECD member states in 1976. So many years ago, but this document was several times was updated during the years, and the last update was in 2011, but the important update was in 2000 year, where the in the guidelines was at the rule of establishing the national contact points for responsible business conduct, which is the grievance mechanism, just making able to people and also for the NGOs, for different groups, possibility to bring the case if there is the situation when the company is not following the rules set up in the guidelines. As you see, also the guidelines is completed by 11 chapters, but the 11th chapter was, 11th chapter was added in 2011. It was the chapter regarding human rights after the adoption of the United Nations, the UN Guiding Principles on Business and Human Rights. Before it was only 10 chapters. And the main important chapter, let's say core part of the OECD guidelines is the human rights, the disclosure part chapter, the employment and employment and business relations chapter, environment, consumer protection, combating bribery, chapter regarding sciences and technology, which is not popular in the other CSR or ESG standards, as well as the chapter regarding taxation. It is also the CSR concept, not really covered the taxation part. And the last one is the competition. What is important also, going back to the NCPs, that after this 2000, when the national contact points were set up by the guidelines, today in 2023, they are operating in the 53 countries. 38 from them, they are the OECD members, states, countries, and 13, as you can see on the slide, 15 of them, they are the non-members of the OECD, but they are countries, we call them the countries who adhere to the OECD guidelines, the countries who are implementing in practice the OECD guidelines. And also the guidelines itself, they don't have, there is as you know, this 11 chapters, and the other part of the guidelines is the procedural part, which is explaining everything about the functioning of national contact points, as well as the procedure, how should be the a consideration of the cases should be handling by the national contact points. What is important information for you, that this 2011 update of the guidelines was not the last one. It was the last, but there we have just new one. It is very important that we know that in the next week, on the 8th of June, there will be the meeting of the Ministerial Council of the OECD, which we are expecting will adopt the new update of the OECD guidelines for multinational enterprises. It was the huge process to prepare this new update. It starts in 2020 with the stock-taking exercise, when the working group, which is operating between the OECD and operating and acting for the responsible business conduct, was looking inside into the OECD M&E guidelines, just asking ourselves and also making the public consultation if the guidelines are really connected with the reality. Because as you know, from the 1976 till today, a lot of change. Even there was the last update in 2011, but there is a lot of going on, mostly in the European Union. As you know, there are a lot of, excuse me, there are a lot of new regulations coming on the ground. For example, the regulation of regarding it was today voted, yes, it was today voted in the European Parliament, the concept of the European directive, sorry, European directive regarding the corporate due diligence in the sphere of the human rights and the environment. But this is not only one. There are several other regulations on the EU grant. For example, the CSRD, the directive regarding the corporate sustainability reporting, which makes now the new scope of this obligation for the companies, which also includes the issue of human rights. And there are also several other regulations. So this exercise, let's say, the stock taking report and stock taking exercise was really very important, just to have the possibility to update the guidelines in the light of the new trends in the regulations, but also in the new trends of the, let's say, corporate sustainability, social responsibility, RBC, ESG, all this concept of the responsibility of the company. So be aware that the next week, 8th of June, probably the ministerial meeting of the OECD will adopt the new version of this OECD guidelines, and it should be, promoted widely. And since 8th of June, we should follow this new version of the document. And this is the one, the main document in the OECD regarding the responsible business conduct. But also, maybe maybe you will be interested to know that there are also several sectoral guidelines elaborated by the OECD. There are 5 sectors. The OECD especially prepared additional documents in which they are explanation for the companies how they could really in practice implement the OECD M&E guidelines. And these 5 sectors are the, I don't know, here is working. Here. Oh, here. So here we have the extractive sector, which OECD's understanding of the extractive sector is very broad, from the mining company, from the company who are making the search of the minerals, to the oil companies and to companies of energy. So the extractive sector is very broad. To this sector is also included the sector of conflict minerals. I'm sure that you are aware what does it mean, conflict minerals. The next is the sector of garment and footwear. The next is agriculture, and very important, the financial sector, which has here on the slide, you have 2 documents, but actually they are already 3 documents elaborated especially for the financial sector. As you know, it is very important from the point of view of the investment and corporate lending, and generally from the point of view, also from the insuring point of view. So for the financial sector, we have 2, and the new one, they are 3 documents. Also very important, and I very recommend you, if you're not aware about this document, that the OECD in 2018 published the due diligence guidance for responsible business conduct. And this is very practical document, in very practical way, explaining how the due diligence could be implemented in practice by the companies. The first part is explaining the first 6 steps of the due diligence, and the second part of this document is answering the questions the companies might have, how it should be in practice implemented. So this is the general overview of the OECD, let's say, responsible business conduct standards. And now a few words about the national contact points, especially about our Polish national contact point, which was a Polish national contact point, of course, was established after the Polish accession to the OECD. Poland becomes a member of the OECD in 1996. On the very beginning, the NCP was located in some ministries. Then it was located in the Polish Information and Foreign Investment Agency. And from June 1 of 2016, the NCP was moved to the ministerial structure, to the Ministry of Development, then to the Ministry of Investment and Development, and now finally it is in Ministry of Development Funds and Regional Policy. And it might be for you strange that there are several different ministries, but in fact this is the same ministry from the 2016, but after the elections and the changes in the public administration, the name of the ministries are changed. But in fact, from 2016, we are operating in the same place and in the same office, let's say. Why, from the point of view of protection of human rights and the human rights from the point of view of business operation and possible doing harm by business to the people and to having the negative impact, this is very important to have some place when the people could go and make some complaint. And this is the one of the tasks of the national contact points. To contact procedure if we receive some information, some very concrete notification that some company potentially breach the rules established in the OECD guidelines for multinational enterprises, the NCP is starting the procedure and starting handling the case. And this is one of the tasks, but also the other one, also important, is to make promotion of the OECD guidelines and the OECD RBC standards. So this is two main important tasks for the NCP. And as I said, the Polish NCP now is located in the Ministry of Development Funds and Regional Policy. You have received actually in the materials this a very short brochure, I think it is very clear, very transparent information about the general about the OECD standard and also about the Polish NCP. Also, we have the website, which is established in two languages, in Polish and English, and it means that the same content we have in the Polish website, the same content is also presented on the English version of this website. And for the Russian-speaking participants here, there is information that we have also some documents and some important documents and materials on this website, published also in Russian and in Ukrainian. If you will ask me why, it was not the decision last connected with the war in the Ukraine, but few years ago, we published this document, as I am aware, in 2018, because a lot of people from the Russian-speaking countries, as well as from the Ukraine, are coming to Poland, and Poland is the big labor market also for this group of workers. So for us, it was very important that they could be also aware about this mechanism, which is the national contact point. And this here, I will show you some examples. So you can see that the main important document, which is the contact procedure, which explains how the NCP is acting when receive the information, the notification that some company is potentially breaching the guidelines. These documents, this conduct procedure is published in Polish, English, Russian, and Ukraine languages. And also we have this procedure is not so long, but it has some pages, almost 10 pages, and to make easier just to understand how this process is going on, what the NCP is doing. We have also this very practical flow chart, which is explaining how the process is going on, which is important for the parties of this cases conducted by the NCP to be aware what will be the next step, how it will be, what kind of possibility could be, for example, if the company will not agree to make come to the table for the mediation, what could be done in this situation. So this is in English, but also this document is available in Russian as well as the Ukrainian languages. I don't know how much time we have, but Beata asked us to prepare a small practical exercise with you. Before I will go to that, one more information. Quite important regarding the core criteria, how the NC, the national contact points, how they are operating. The most important, there are 4 criteria how we are operating. It is the visibility, accessibility, transparency, and accessibility. Visibility, it is expected that the NCP should be, first of all, established. Second of all, should have some website, phone number, email address. It should be accessible and visible for the people. And this accessibility means that it should be really working in practice, not only have the phone number, but nobody pick up the phone when the phone is ringing. Also, the transparency means that we should be transparent, and we are publishing our annual reports. Also, we publish them in Polish and English, so you could find them on our website. And accountability means also that we should be accountable through, which is covered in our case through our annual reports. When we are considering the cases in this language of the OECD, the cases, we are calling them specific instances. Sometimes you can find also this in literature, this term. When we are dealing with the cases, we are obliged also to follow some important rules. One of the most important rules in handling the cases is the confidentiality. Why this is important? Because the NCP is not the court, which is also, we are always explaining this to the companies, that the NCP is not the court and we are not judging the companies, but what the role of the NCP is to help both parties, the company and the notifier who bring the case, how to find the solution if there is the conflict, or if there really is potential breach of the OECD guidelines. But confidentiality is really very important from the both point of views. Sometimes the companies has some confidential information that should be not shared from the point of view of the competition. On the other hand, there could be the important confidentiality issue from the point of view of the notifier, because they could be, let's say, the employer could have some could be afraid that the employer could fire them after this bringing the case to the NCP. So in the light of the reaching the solution and reaching the agreement between the parties, the confidentiality is really very important. and the NCP is always underlying that this is the really important role. But there are also others like impartiality, predictability, justice, which means that we are treating the parties in the case on the equal level. Even we have sometimes really very big company which is employing a lot of thousands of people, and on the other side of the table we have one individual person. They are the same. They have the same possibility to bring the information and to take the floor, to take to present the statements during the handling the cases. And one rule is really very important, because sometimes the notifier who is bringing the case to the NCP is just saying about the situation, and there is some conflict between these two parties to the proceeding. But the role of the NCP is also to look at this conflict situation or this case just from the point of view of the OECD guidelines. So this is this role that we should take this situation in compliance with the OECD guidelines, which sometimes is really, I must tell you from the practice, is really very difficult, because when the people are going to mediation, which is the most important tool and instrument we are working with the parties, people are going deeply to the conflict, and everyone is just losing the OECD guidelines from their mind. They just want to solve the conflicts of the situation, but this international role of the responsible business conduct is not so much important. So this is the role of the NCP, just to bring the information that we are going and to find the solution, but the solution should be elaborated. This agreement between the parties should be elaborated also from the point of view of the OECD guidelines. So this is the main part of this my presentation, and then I would like to make the practical exercise with you. But maybe on this stage you might have some question which you would like to find the answer.
Procedure for dealing with some also sustainability issues. Could you maybe provide us with some general view on the scale of the cases that the NCP is dealing with? And also, like, what are the typical, what is the proportion of the cases being mediated successfully, or are not able to bring the parties to an acceptable result? That would be very interesting. Thank you.
Okay, thank you very much. This is a very interesting question, and I am prepared for this question. Just I have one slide. This is all information you can find in the internet on the OECD database about the cases that they are handling by the NCPs. So in this database, they are the records of 6,050 for today cases. What was interesting that we receive as the NCPs in this global scale, we observed that they are increasing number of the cases after 2011. And after 2011, and most of them were regarding human rights chapter, and very often it has happened that the complaints that they are dealing with the human rights chapter are also connected with the chapter 5, which is the relation and which is will go to employment and industrial relation chapter. Very popular, let's say, in this in brackets, this very popular chapter is also the disclosure. Environment, of course. Environment is almost on the same level as the human rights. Very few cases, they are from the chapter science and technology, but they are also very interested cases. For example, there are cases regarding the intellectual property, and also with the some innovators, just protection of the innovators, very interesting cases. Also, very few cases are in the chapter of taxation. But general, what is the proportion between the we'll go to the database. What is the proportion between these cases which ended with successfully and not? I must say that there is I don't remember very exactly for today, but let's say if we have this if we have this 650 cases, half of them, over than half of them, they were ended with the agreement between the parties. And but there is, because I just forgot to tell you that if we have this 51 NCPs around the globe, every NCP is operating on the base of its own procedure. So the procedures between the NCPs differ, not very much, because this second part of the guidelines is just bringing the general overview how the procedure should looks like, but they are not the same procedures. So if you will consider just to bring the case to the Polish NCP or to the Ukrainian NCP, because Ukraine also is the member and of this NCP network, or to the Kazakhstan NCP, I know that there are some people from Kazakhstan here, or to the, let's say, French, Denmark, and so on. The first step you should go to the website of the NCP and to read the procedure. It is really very important because, as I said, the procedure might differ from the different point of view. And maybe what will be important also and interesting for you to know, what is this final result? Sometimes it happened that the parties are reaching agreement, and after this I will go and I will tell you this on the Polish NCP example. And if there is agreement between the parties, there is the final statement preparing by the NCP, and this final statement is published on the website. And in this document you will find the explanation, all information about the case, which chapters were where this case was delivered, and what was the result. Sometimes in some NCPs there is this agreement between the parties is the part of the final statement. Sometimes not. Sometimes it's already everything is depending of the procedure. But the general rule, also this might be interesting for you. The general rule is that we have in the NCPs 3 documents, which are result of the considering of the case. The first one is the initial assessment. It is after the NCP is receiving the notification, and after several meetings with the parties and the very detailed studies of the case, the NCP is preparing this initial assessment and taking the decision if the case is taking into consideration or not. Because there could be different situation. There could be the situation that that the case is not really connected with the guidelines. It could be just some imagination of the person who is bringing this case, that it might be the situation that the guidelines is breached. So it is very dedicated studies if this case should be taken into consideration. And this initial assessment is making after the NCP is making decision if we are taking this case to the consideration or not. If yes, then we are offering to the parties mediation, or to the, we call this good offices. Mediation, it is just, this is the alternative dispute resolution tool. We have the table, two parties, and the mediator who is mediating till the end if they reach agreement or not. Good offices is a bit different. It is, we are using the technique of mediation, but we are taking the conversation with the parties in the light of the OECD guidelines. This is this important difference. Sometimes, especially in Polish language, this good offices is very difficult to explain. What does it mean? So we are explaining that this is the common talks with the parties in the presence of the NCP representatives, something like mediation, but mediation with the this OECD guidelines spirit, let's say. And after this, if the parties agreed, because it should be, sometimes it happens, going to a question if it is the success or not. Sometimes it happens that the company is not ready and it is not agreed to go to the mediation. So in this case, we have the path that if the company is refusing to go to the mediation, the NCP is considering the case on its own, and then is going back to the company, proposing some solution. And still, if it is not, so we are if we are just publishing the final statement with the information that there was not involvement from the company point of view. From the company side. If there is, everything is going well, just let's say like in this procedure. So we have the mediation, the party agrees, we have mediation, they have the agreement. Then we are publishing this final statement, and in this final statement, usually, but there are also some situations that it is not possible to do. We are going to the third stage, which is the monitoring, which means that after 1 year, usually after 1 year, the NCP is calling the party to check if everything what was set up in the agreement, if everything was really implemented in practice. So I still don't know how much time do we have more, if we can do this. So we have like 10 to 3 minutes. Because what I would like you to do, I just would like to propose you this some kind of practical exercise. Just to do, it was my idea that I would like to divide you in 3 groups. One will be the group of the individuals who are considering to bringing the case to the NCP. The second group will be the NGOs representatives, and the third group will be the trade unions representatives. And you have some situation. I don't put the hypothetical situation. Just take the general information that some company X, which is the big multinational company, hiring, let's say, 6,000 people here, let's say in Poland, but is operating also broadly in the other countries, is potentially breaching the OECD guidelines rules. And you, as the individual or as the NGO or as the trade unions, would like to bring the case to the NCP. And the question to you will be, what is the pro and con? It is really, from this point of view of this group, what will be the important but you have to help me with explaining this task. What will be the, co będzie takim dużą zaletą właśnie w tym, żeby właśnie pójść do NCP, a nie do sądu na przykład?
So what would be the key advantage to go and submit complaint to NCP and not to go to the court in the first place?
So I don't know how we can divine you, and I have some copies.
I can just say 1, 2, 3.
1, 2, 3. Okay.
Markus, do you want to participate? Because it's the advantage, but I think you don't mind. 2. So 1, 2, and then 3, 1. Yes. So this is 1, 2, 3. 1, 2, 3. 1. 3. 1. And Kaya is 1. Irne, can I put you into the group? Hello. 2, 3, 1, 2, and that's it. So I suggest number 1's going to this corner, number 2, and number 3 towards the back. A bit of the exercise. Number 1, it's over here. Just the other end of the row. Number 2, and number 3 towards the back. Peer groups. We need to present.
So maybe we will start from the group number 1, which was the biggest one. And also, I must say that bringing the case to the NCP from the individual perspective is really not easy one. So I'm very interested what you find.
Thank you very much. We have 2 spokespersons, and now they went away. Where are they now? There's the first one for the pros is here and the cons is here.
Hello, my name is Paulina. I'm representing Prof Pharma, so based in Warsaw, and pros. I will begin from the last pros. So when it's shortcut cases, it's better to go to the local court because of many issues, but to make that issue shorter and to don't make works of institution, you know, not to give them very simple issues. Other is that OECD and the point have wider and bigger perspective. I mean, they see bigger picture, that not only the local law and not only the local obligation and the system of law. And when we are talking about multinational enterprise, is really important, because we can have many situations like employee is working, for example, in Warsaw, based here, but his or her nationality is from different country. So we need really wide perspective and taking into account to not only local law. Other pros was, could you please support me? What was, we took to the conclusion that it also, in many cases, or in some cases, it depends, because it's about the aim of the individual. If she or her wants to stay in the company, or just want to fight for the rule, or just if you want to leave the job because you are done, you don't want to work for that company, the mediation is completely without sense. But if you really want to fight for your rights and you want to make some change in that company, it's better to start a mediation, because it's possible that that effect of that mediation will change not only behavior of that company, but other environment, other business environment in the place.
Yes, thank you very much for this. And I understand
also
we
a
have
contra
okay.
argument. Sorry.
I'll do the skeptical part. Not every case is suitable for mediation. If there are already gross violations of human rights or manifest breaches of law, what to mediate about? Someone must just go to prison, or the company must shut down its operation. So yes, a mediation is about cases where parties want to preserve their relationship. But if I, as individual, seek retaliation, better go to court. And I presume this procedure is not necessarily quicker, faster than court proceedings.
It is not quicker, faster than court procedure. There are some framework or timeline of the procedure. It should be finished within the 12 months, but in practice, I must tell you that some cases are considering doing 3, even 5 years. So it happens. Thank you very much for all of this, but I would add one more information in our argument in cons, from the cons perspective, because when you are bringing the case as an individual to the NCP, even also to the court, it is one very important aspect. It is the legal advice. Sometimes the people who are really affected by the company, they don't know the law. They have some information, but they are not the experts of the international law. So sometimes it is really important to provide to the individual also some legal advice. And you have the question?
Yes. I just had a question regarding the capacity and the expertise of the people actually in the NCP, because an example that I can give in Bulgaria is sometimes people are working there, but do they understand the human rights component? And this is a very interesting point. How do you ensure and how do you train your staff to be a bit more sensitive and to understand the human rights framework?
Very, very good question. And to answer it, I will tell you in our Polish situation. First of all, the Polish NCP is composed now from 2 people, 2 high-level civil servants. And we are the professional mediators also, and we have really outstanding knowledge about the human rights, because the Polish NCP was also the institution which was involved in developing of the Polish National Action Plan on Business and Human Rights. But it is right, in the other countries, the role of the NCP and the knowledge of the members of the NCP about the human rights is really not so deep. So you are right that there is the need of the including the NCP also in this national action plans on business and human rights, but also some additional training and so on. Yeah. Can we go to the group 2, where there was the considering to bring the case to the NCP from the NGO perspective? Some from this group, you had the very good expert there.
Yeah, we didn't have time to it's working. We didn't have time to choose anybody to talk because I was talking all the time. Sorry for that. We had a huge conflict of interest because I'm representing NGO and I filed cases before the NCP. So yeah, I was talking. So advantages from my personal perspective. First of all, much quicker procedure. We are in Poland, and it's much quicker than the court cases, especially if we think about more than one instance. And of course, I was counting that 1 week ago, I think, how long the proceedings take place in Poland. I think that one fitted in this 12 months exactly. The rest was a little bit longer, but still quicker than the court. So that's the first advantage. The second advantage is that the NCP procedure for us is the last resort procedure. So if we cannot start anything else, and that was the case of almost all cases that are conducted by the NCP, then we choose the NCP, and it makes sense as we can see finally, because the Polish NCP finished so far, that the new Polish NCP, I mean in the ministry where it's located right now, finished 3 cases, and all 3 were finished with the agreement. So far 100% rate of agreement, so big success. So that was the second advantage. The next one, I think, is also that the companies feel that they should engage in the proceeding and should start to debate, discuss, mediate with the notifier. And it's not so obvious before the court. Before the court, it's rather conflict, it's rather opposition, just because there should be the opposition, because that's how the court process works. And before the NCP, I think that it's quite different. That's the first. The third advantage. The fourth might be connected with money. In fact, it's free of charge, and there's also no risk of paying anything afterwards if you in inverted commas lose such a case. So that would be the next one. Going to disadvantages. Let's say ban, even, because it's quite strong. Ban on communication of the case during the mediation is ongoing. So NGO cannot really use for any communication in these cases, and there are some proofs of the situation. There was such case, Friends of the Earth Europe, as I remember, and Greenpeace against Shell, and it ended very early because those organizations started huge communication about the case, and Shell said, sorry guys, but we are not going to discuss anything with you further. So that's the point, that NGOs very often want to communicate, want to make some fuss, want to publish some press releases, articles, and so on, use social media channels, and they cannot during the procedure. The next disadvantage will be connected with balance of powers, I would say. So we have this experience that on the one side we've got individual or the NGO, an NGO without any lawyers, any experts, and so on. And on the other hand, we've got the company with team of lawyers entering the room, and that's a problem. But it's also the problem of every other type of proceedings. Any more disadvantages? One big disadvantage, my very personal one, unfortunately, and our case against Frank Bolt against OLX connected with lack of capacities on the side of the NGO. So that's a problem. If we've got a court ruling, there's some type of execution, and all this burden of execution and performing the verdicts is on the side of the company. However, after the NCP proceedings, the NGO has to engage in the fulfilling the agreement, and not always there is this capacities to do this, and that's a problem very often in these cases. For sure, there are more advantages and disadvantages, but that's all.
Thank you very much for all this. So you were able to present to us. I will add only one information, that this campaigning doing by NGOs is really sometimes a big problem for the NCPs, but also for the cases itself. And there is the reason, this campaigning doing by the NGOs is the reason that sometimes the cases are just closed before they're reaching the agreement, because it is breaching the rule of the confidentiality. Even the NCP understand that the NGO would like to have publicity and make loud and spread loud information about the importance of the case, but still the confidentiality is the main rules in the proceeding of the NCP. I don't know if we have time for the trade union, for the third group.
We always should have time for trade unions. I would just request that you present it in a condensed way.
As the smallest group, please present this in the condensed form.
I think that the presentation of NGOs was so full that we can agree with most pros and cons. As a trade union, we also, as a main pros, find the time of the this initial assessment. Also, we thought about the information that we could use if we if our subject won't be accepted. And we also thought about the law help that we will get during the information. We also thought about the feedback information that we have to the member of trade unions, and 3 months is very optimistic and short time as a Polish law, which we defined as a main cons. Do we have more?
I would like just to add, for example, when we are talking about the position of labor trade union, especially in our country, in Kyrgyzstan, it's very important for us to take into account the national law regarding the labor rights, because sometimes there can be a lot of bureaucracy and initial barriers. And in this regard, it's also very important for our further comprehensive analysis, because if sometimes position of trade unions cannot be can be changed, because we have a lot of trade unions, and in this regard it's also very meaningful.
Of course, you are right with this issue of the local law. In the first chapter of the OECD guidelines, there is the provision, the very first provision, that the companies operating in the country should follow the law, the local law. And the next, but they could be situation when the company is going, for example, with some operation in the country where the local law is not it's not agreeable with the OECD guidelines. It's not where some issues are not covered by the local law. In this situation, the OECD guidelines is the higher than in the hierarchy of law than the local law. But first of all, we are looking also, of course, in our Polish NCP, if the companies are following the Polish labor law, as you said. Yes. And one more advice for the trade union group. Very often some trade unions operating in the companies are forgetting the information that they trade union, very often they are members of the bigger federation. So sometimes it is also important to include the case, the federation of trade unions that this trade union is the part of, just to have this legal advice, for example, from the federation, or some other help of the federation activities. So I think that we have to stop here. I thank you very much for your activity and involvement in this practical exercise, and I hope that you find this interesting for you. And just very last, I will say, announcement from my side. On the 27th of June, Polish NCP will organize the international conference on this update of the OECD M&E guidelines, and we will be doing the streaming, which will be in English. So I will ask Beata to send also to you the link. If you will be interested to join us, we will be very happy. Thank you very much, and I wish you all the best. Very interesting time doing this conference, and very good time in Warsaw.
Thank you very much, Jacqueline. Also presentation and the workshops. And thank you so much. And as I've mentioned, we've moved the last part of our morning program to the afternoon. So now you have time for lunch, and we'll come back. I'm optimistic that we'll be back here at 2:30, but we might have like 5 minutes of a grace period after that. But so, you know, have your lunch up until 2:30, and then have 5 minutes to kind of get the tea and move back to the room. Okay, we'll come back after the break. Sorry to have kept the lunch a little bit shorter than we have initially intended. but as we would want to try at least to finish it, but as we would want, okay, good, thank you. But as we would like to finish at 4:30, not to keep you longer, so yeah, tough decisions had to be made. So now I would like to invite you to our official launch of the case studies publication. And it's really with a great pleasure that we'll be handing to you this publication in a few moments. And the publication is published within our working paper series, and it's basically a collection of business and human rights case studies from Central Eastern Europe and Central Asia. And they have been developed by all the, not all, but by half of the participants of the Summer Academy. And the Summer Academy, the first edition of which was held in September last year. And then those participants who have completed the Summer Academy, the core Summer Academy, which lasted 5 days, and who got the certificates, they could participate later on in a series of webinars and also write case study to obtain a diploma of the Summer Academy. Basically, we all know that you can participate in a course and don't remember anything. So we wanted to make sure that those people who will get the diploma, that we can really say that they know at least the basics of human rights and that they've got an idea what human rights due diligence is about. So I should add that the cases that are covered by our participants are based on the publicly available information, and they do concern real cases. So don't be surprised to see the names of the companies. It's all based on the publicly available information, but it's important to bear in mind also because not all information relevant to the case is obviously in the public domain. So what we have are case studies and suggestions how situations should be solved now kind of with from the perspective of human rights due diligence, but obviously it's limited to this by the fact that it's just based on the public information. And as you can obviously understand, it's the whole publication and case study and everything is our way of trying to respond to the challenge of the lack of competences in the region. And we can really say that people who have wrote those case studies really get to know what it's all about. And I know that it was said already, but we really do hope that the publication, the whole process of writing it is just kind of one of the steps on building the network of experts in the region. One more thing perhaps to say about the publication is that it's intended to be used as a self-learning or teaching material in the region, but also beyond. What we found basically is that very often teaching materials, publications about business and human rights do refer to a number of very famous cases, tragic cases, unfortunately, but which are basically situations which happened in Nigeria, Bangladesh, several other regions, but not in our region. And it's much easier to think about business and human rights when you've got a case study to which you can relate and which is basically set in the region where you live. It just makes it much more tangible. So the way that the publication is structured, it's you've got a selection of case studies. Each case study starts with a short description. And then there are a number of questions about who are the rights holders, who are the stakeholders. So what the company should do now, what would be the right steps to be taken as part of the human rights due diligence? And there are a couple of more questions. So you'll have a chance to explore in a moment. And one last thing probably to add is that this publication was never intended to be an academic paper. And actually, authors did write much more elaborate pieces than you'll receive. There was much more of the background, kind of much more academic background, but we were limited by the number of pages. Unfortunately, the realities of that. But we also wanted this material to be practical. And we wanted our participants to look not from the perspective of an academic who writes generally about what's important. And sorry, I'm not trying to be dismissive of academics, but just kind of, we wanted them to kind of think in terms of practical approach. Okay, there is a company, some bad things happened. I'm not now hired as a human rights expert by this company, and now I need to deal with that. Where do I start? So that was the approach that we've asked our participants to take. And as we hand over this publication to the broader public, I should say, obviously, huge thanks and congratulations to the authors, but also to all those who made the Summer Academy possible. So the Global Business Initiative for Human Rights, who helped to design the whole practical section of the Summer Academy, obviously to the funders, to the Polish Institute team, who was really working hard behind it, to Olena and her team from Yaroslav Mudryi University, but also to all the mentors, to all the academics and practitioners who provided guidance to the authors throughout the process. And let me just mention those people, because it's really big, huge thanks from our side, because they did it in their free time. It was done on pro bono basis. So I would like to thank Guðmundur Alfredsson, Nadia Bernas, Jernej Letner-Czernicz, Dirk Hoffman, Bartosz Kwiatkowski, Chiara Maggi, Peter Muchliński, Claire Medfin-O'Brien, Ron Popper, Agata Rudnicka, and Andrea Schemberg, as well as Olena Uvarova. And then I was also doing my tweaks and comments, so probably everybody hated me at the end of the process, but I hope that the end result is satisfying to all. And yeah, I just really hope that it's just the beginning of your adventure in business and human rights, and that it's also just the end of the beginning of what we hope will become a very strong network of experts. And as we have quite a few of you today among us, and I mean participants, I just want to take like up to 10 minutes of the time to hand over to you the diplomas, and I would like also Olena to come up and help me with this wonderful task. And Olena, obviously, if you want to add anything, it's no. Olena never wants to add anything, but she has a lot to say, so.
And the first diploma is going to Gulnaz Bayturova.
Congratulations. The second, Anna, you shouldn't run away. And the second diploma, obviously they are not ranked. It's just alphabetic order for clarity, right? So Anna, it's over to you.
And next one is for Ruhia Isaeva.
Okay, it might take me longer. And Murat, the next one is to you. Oh, right. Okay. I was practicing this over break, so hopefully I won't. Namoli Hachikashvili. Yay.
And next one for Mariusz Kośla.
Okay, and this one I didn't practice, so apologies in advance. Akaki Kukalaishvili.
And this diploma is for Franciszek Nowak.
And the next one goes to Olga Nikolaeva Paneva.
Thank you so much. Thank you so much.
And Valeria Pojedynak.
And the last one goes to Kaya Tila. Unfortunately, 4 of our participants couldn't come today, so we'll send the diplomas to them by post, but Kaya is still with us, likely. Because the biggest fears that we had at the beginning was that all of the participants will decide to stop at the stage of certificates. And now, to give you a bit of a taste before tomorrow of the case studies that are covered, we have 3 presentations this afternoon. And I would like to invite Anna Dangova Hug, and later it will be Mariusz Kośla, and last one will be Nana Hekachishvili. Okay, once it was good, now it's sorry. And they will present 3 case studies. One will be from North Macedonia, the second from Poland, and the last one will be from Georgia. And we'll have a Q&A session after the presentations. So you'll decide. If you want to have questions straight after each presentation, we can have them through each of the presentation. Up to you. So Anna, the floor is yours, and I'll set up your presentation.
I prefer to sit because there are a little bit technical terms that I need to read. Otherwise, I don't read presentation, but this text I would like to read so that it's more precise. First, a huge pleasure to be here and be speaking about the case studies. It was a very interesting process, and I would like also to thank to my mentor in writing the case. Firstly, just a little bit of the context how I got to know this case. I was engaged as a lawyer of the NGO who wanted to bring this case in the court, but because they didn't have any budget, they decided to just leave it like that. But I thought it's a very interesting case to see it through the lens of the UNGPs. So it is about, okay. I hope you can see it. So Jugohrom, it's an industrial plant for chromium products and ferroalloys, and it was founded by the government of now North Macedonia back in 1950s. The plant has a very particular location, and it is located on the left bank of River Vardar. Those who have been know that we have a very big river that across the country, and it is 15 kilometers from Tetovo and 30 kilometers upstream from Skopje within the village Jegunovce. And ferroalloys contain certain chemical elements for the need of the steel industry. And in the 1980s, this plant was the leading industrial plant in the country with more than 7,000 employees. However, the production was stopped in December 2001, followed by the company's privatization. And there were a lot of companies who took over the plant, and Jugohrom ferroalloys was the last one. So now I'm just gonna use the term Jugohrom because otherwise the term is very, very long. Jugohrom possessed an A adjustment permit with an adjustment plan as a condition for continuation until compliance to get an integrated environmental permit. The Ministry of Environment and Physical Planning, which is the ministry in charge of just screening how this plant is working, issued a draft amendment of the A adjustment permit prescribing the conditions and terms for the facility's waste management. But the operator did not fulfill the criteria, and therefore the state inspectorate decided to issue a decision not to renew the license, and therefore the plant ceased to exist. And as the operator lost this license, he was obliged by the law to fulfill certain tasks. It needed to dislocate the premises, the equipment, and the waste that can endanger the environment. In addition, according to law, it was bound to produce an annual report to the ministry for the measures undertaken to prevent environmental damage and envisage financial resources for remediation of any incidents. It didn't produce any annual plan, and plus the annual plan on the ministry did not mention that this plan exists at all. There are a couple of actors in human rights concerns about this plan. Why is it so important? This site is of a significant concern because of the presence of six-valent chromium due to the former production of sodium dichromate. I'm not a chemist, I don't know what is the component, but I know that it is, there are indications it can cause cancer. Jugohrom today is considered as a hotspot in the region with medium environmental risk. Currently, there are around 7,500 tons of this six-valent chromium, and they are stored in a landfill, which is 23 meters high. There is no new dangerous waste that is produced, and the stored dangerous waste of the chrom is purified via this drainage system and a purified station, and then it is spilled as a non-active chrom in the river Vardar. There is a real threat that the landfill pollute the waters of Arasce Spring, and the Arasce Spring is the main principal water supply source for the capital Skopje and beyond. There are a couple of actors involved, and that's why this case is particularly interesting in terms of, for us lawyers, to answer the question, who is responsible. So the government is the landfill founder, and Jugohrom manages the purifying station. On the other hand, the ministry operates the dump and the drainage system and financially assists in maintaining the purifying station. The Ministry of Environment is a waste holder, and we have two municipalities, Jegunovce, where the landfill is located, and also municipality Skopje concerning the drinking water. And now I will kind of tell a little bit about the incident that really kind of triggered a lot of media attention. So in October 2021, communities of Jegunovce noticed that the river Vardar was polluted with wastewater of green and yellow color. And you can see here how it looks like with a drone. It was later found to be from this industrial plant. And in addition, activists have warned that this Jugohrom has also polluted the groundwaters of the mountain Jeden, where the village Jegunovce is situated, as well as the springs of Rasce. And according to official documents, which were issued by the Ministry of Environment and Physical Planning at that time, the purifying station was not functioning, and in the upcoming period in function, but with a lower capacity. The ministry announced that it will open 3 public tenders for the purifying station, but there are no official data whether these elements for the purifying station have been procured. And this incident was really followed by intense media reporting, which showed pictures of this yellow water in the village. And the dilemma is that the eco-activists would like that the whole waste of the landfill is relocated, which costs a lot of money. And on the other hand, the government is preparing a plan to construct a new purifying station. So a little bit about the right holders. You can imagine there are a lot of right holders, like people living in Jegunovce, people living in Skopje, fishers fishing in Vardar, farmers in the region, but also future generations, because this is a very big landfill. Stakeholders, we have eco-activists, local municipalities, and the government of North Macedonia. As for the rights, there are a lot of them: the right to life, the right to health, the right to water, to property, to food, and now the new one, the clean, healthy, and sustainable environment. So, as many actors bear some form of responsibility in this case under national law for the operation of Jugohrom, a question arises whether this is a case for contribution or causation. So whether all of these actors have contributed, including the company, or they have caused human rights harms. So on one hand, as the company is responsible for the management and supervision of the plant, but the landfill ownership and financial assistance is on the state side, we can argue that both of them are contributing to the risks and have shared responsibility for the human rights violations. On one hand, Jegunovce has failed to properly manage the purifying station, contributing to the pollution of River Vardar and the groundwaters. And this pollution has been negatively impacting the enjoyment of the human rights of all the right holders that we've mentioned. On the other hand, the state failed to act promptly in line with national and international law to take steps to prevent, to investigate, and to remedy for the human rights harms. But on the other hand, driven by the principle the polluter pays, one is inclined to conclude that it is actually the company that has caused negative human rights impacts. The government, it is true that the government was very late in acting in line with the law, but still the main cause rests with Jugohrom. Now I would just skip these 2 slides and go to the human rights due diligence process. So hypothetically, if this company engages an expertise to kind of guide them in this journey to become a responsible company, and we put the human rights due diligence lens, we can discuss what the company can do. So in line with UNGP 18, Jugohrom should identify and assess whether and how its operations are leading to adverse human rights impacts. And in doing so, it should have a differentiated approach in order to integrate the perspectives of certain groups, such as elderly people or children. This assessment should be ongoing, and it should reflect also the complexity of the company. In line with UNGP 24, the company should prioritize its action based on severity. And here as a criteria, we have the scale, the scope, and remediability of the impacts. Following the assessment, the company should address the human rights risks based on whether it has caused or contributed to them. So if you take the scenario of causation, the company should cease or prevent actual harm. If we speak about contribution, it should cease, prevent, but also leverage to mitigate any remaining impacts to the greatest extent possible and provide a remedy to the affected individuals. In line with the Pillar 3 of the UNGPs and UN Guiding Principle 31, you should also design a company-based grievance mechanism, but also as the government is one of the concerned actors in collaboration with the UNOFC, the government can adopt a special fund to compensate the citizens of the UNOFC for the harm caused. There should be absolutely a meaningful consultation with all stakeholders and right holders so that their needs are met and any barriers of remedy are addressed. But also when we speak about grievance mechanisms concretely in this case, I think that the company should be realistic whether actually the grievance mechanisms will be the right avenue. And managers may need to decide whether to prefer judicial access to remedy over a speedy response by the company-based grievance mechanism. And I'm saying this because a grievance mechanism in this case may not be the right avenue, knowing the cumulative human rights impacts on the shareholders that have been happening for a longer period of time. And I personally think that the judicial channel is a better avenue. So I think that in a nutshell, this is a very interesting case. Also for the students when they're going to discuss to decide whether it's one of causation or contribution, but also it can open up issues regarding the access to remedy, knowing the standards, the BH, business and human rights standards. So you can always have pros and cons, which might lead to interesting discussions for the students. Thank you.
Thank you very much, Anna. And the question to you all, do you have any questions? Would you suggest anything? Oh, yeah. Yep.
Thank you, Anna. Very interesting case. I probably missed it, but if you can just take us through. So how are the stakeholders, how did they come to you, or how have they been supported through NGOs, or what's going on? Has anyone been speaking to the different stakeholders you mentioned? Because I know that you mentioned quite a few right holders, but I'm not quite sure whether they've been supported and how they've been supported. And if now you rightly said potentially if there is a speak up system, how do you view, or what's going on in your NGO?
The first question, I got to know this case by an NGO who wanted to litigate it in front of the courts. And this is the same NGO that hired us to actually initiate a case in the context of air pollution. And there will be, this case will be written in a business and human rights journal about air pollution. So the main dilemma was who will be the defendants and who will be the plaintiffs. Whether we're going to really try to gather people who are living in Jagunovce as plaintiffs against defendants, but who will be the defendants? Because if you read the national legislation, it's very complex. We are all lawyers. We need to really find a link. And for me, I needed to be transparent and say, look, there's so many actors involved here. I would rather enlist all of them if you want to go, and then the court will decide who is really responsible. So I made these analyses. This case didn't go to the court, but it's very topical, and there are a lot of NGOs now on the spot. And what this case and couple of incidents of this type have triggered is a stream of training and capacity building for lawyers and activists in order to know how to strategically litigate these cases. And secondly, what is happening now, quite frankly, I don't know, because the ministry is not very transparent. There are not a lot of information about what's happening with the purifying station. I know that the government intention is to construct a new one, but that will not solve the problem because you have 7,500 tons of chromium, which will still stay there. And they just need to kind of manage it. And the last part of my presentation was a hypothetical case. What if they engage an expertise now and say, okay, look, we really want to solve this with this lens, what should we do? And then you can decide, kind of design and guide them through the process. I would also definitely engage an expert on environmental science. I think we can't do it alone. Even if you provide a legal advice, you need to be part of a team. If you do a human rights due diligence, you need experts around on these issues.
I'm thinking about the new regulations in the EU about the compliance with OECD guidance and so on. And my question is about the moment when you can say that the company in this hypothetical situation really complies with the guidance. So
with the UNGPs?
Yeah.
Mm-hmm.
So whether it's the moment when they identified and started to do something, or whether this is the moment when they finally did something with the, when you would say that the company is in breach with the guidance.
Do you want to, if you think about litigating the case in front of the court, it depends. The first thing you need to define is the scope, the time period. Which period are you going to take? And the second question is about the term of whether you can actually claim, for example, damages. It depends what you want to achieve. If you want to just achieve a constatation that there have been violations of the human rights in our law, you can do it whenever you want. But if you want to claim damages, that's restricted from 3 years to 5 years. So if you choose a period in the 1960s, that will be rejected from the start. I guess what is important for the courts, if this company have started taking steps in line with the UNGPs, and you go into court and you hire a good lawyer, they would argue that, okay, it's true that we haven't do things, but now we are doing, and this is what we have done. And maybe for the judge, it will be enough to say, okay, this company is in track with the UNGP. They're not brilliant, but they have done something. So I guess it also depends on the forum, whether you go to the administrative court, whether you're going to go to civil court or even criminal court. These are all different strategies for litigation. Both, yeah. Because this is the pillar 3, these are judicial remedies. If you want to go to, we don't have a national action point. Our ombudsman is not doesn't have any mandate for the legal entities. So if they're so fast and establish a grievance mechanism so that they can raise issues and they can solve everything there, that's perfect. But they need to have a solid financial scheme, I would say. So that will be my answer. Yeah.
Additional questions? I don't see. I will have actually 2.
Okay.
And it's both for Anna, but also for the audience. One of the points that you were raising, and we had a bit of a discussion when you were writing the case, that obviously in human rights due diligence kind of sphere, we kind of talk about causation, contribution, direct link, and so on. And we've got this case that you rightly pointed, that we've got those elements of, well, you can argue for causation, but you can also argue for contribution. And I would just kind of be very happy to hear from the audience, what would be your take on this case? Because it's also a different level of responsibility or accountability actually linked to that. But it also has impact on who should take which steps and so on. So I was wondering if you would have any reflections on that, how it looks from your angle. And the second question that I would have is like, do you think that this case could be brought to the attention of any of the NCPs because of the connections with different investors or who owned at a certain point? Yeah.
For the second question, I think it can be if they have the data, if they have evidence, if they have everything, because it will be, you need to open up the past in a way. it has been privatized for a while. There is financial capital, but it's been very difficult to make a link unless you have very strong evidence, I would say. And for the contribution and causation, I would leave to the audience if they want to kind of share their impressions. I have my own opinion, but maybe.
What would be your opinions?
I was thinking about, in the context of the guidance, I was thinking about the contribution when we have at least two entities. So one entity contributes to something that the other entity will do. So in that case, I would say that it's rather causation than contribution, because in that case, what would be the other entity? So the state as the other entity that would be responsible for causation.
I think why is it very, very difficult to make a clear cut is the following. If you want to make a civil liability for the company, then it's causation. Because it's an operator, it's the pollution pays, you have very strong arguments that they have failed to undertake obligations according to national law. If you want to make a declaratory claim and say these actors have failed, all of them, to fulfill their obligation, as a consequence of which human rights violations have happened, and you can enumerate them, then you can put them all in under contribution. This is from my lawyer's perspective. And then you can say the state has failed to fulfill this obligation. The company has failed to fulfill their respective obligation, but all of them have a shared responsibility for the human rights harms. And I guess it is the angle through which you see the case. And that's why I think it's beautiful being a lawyer, that you can reflect all the time.
Thank you, Anna. I have nothing else to add after this comment, unless somebody from the audience wants to. Perfect. Thank you so much. And now I would like to give the floor to Mariusz Kośla, who will talk about the situations which took place in Poland.
Okay, so as you already know, I'm going to present the case from Polish fashion industry, and I'm glad that I can talk about it, because mostly people, also me including, a couple of months ago, when I was thinking about violation of human rights in fashion industry, I was thinking immediately about Asia, and even I came up with this idea. I wanted to elaborate this field from a specific angle, but then thanks to Beata, she showed me that case. So I think it's important to talk, because people think that the problem is not there, problem is somewhere else. And also I would like to say that this case was prepared based on a series of articles which was written by a journalist who is very dedicated to the subject, Grażyna Latoś. So she's not there, but I sent her good energy and thanks. So this company is Polish private company manufacturing for fashion industry, manufacturing menwear. So it's trousers, suits, jackets. This company is located in a small town, and it's the biggest employer. It's important in our case. And even in the region, this is the biggest employer for women, especially. So what is this case about? This case shows a business model which is based on exploitation of employees. In this case, women working as sewers. And so please imagine business model, exploitation, and we have three pillars. First pillar of this business is low basic remuneration, so salary. Second is very high production norm, daily production norm, which is necessary to produce by entire shift. And the third pillar is flexibility of resources. I deliberately use this word for people. Resource, which is the most flexible in this case, were employees. And employees which could not run away from this employer because, as I mentioned just before, they had no real alternatives in this region. About salary, because it's important. This was set at the level so-called minimum wage, which was at the time approximately 300 euro per month. And it was even less because many cases they had to sign artificial fake contracts for part-time job. So in fact, it was part-time paid, but expected full-time job. And one more thing, minimum wage is meant for people who start their career, or they deliver very basic activities and they are inefficient. But this is not that case. In this company, women worked, some of them, for 30 years. They were very experienced. And to produce menwear, sometimes when I look how it is made, it's really complicated. And it's a very hard job. They had to spend so many hours, in such a not natural position. So minimum wage was not for this case. And another pillar, production norm daily. They were set very high and it was independent on circumstances. So entire shift had to deliver some number of suits, for example. Even if it was a new model, which needs some time to train how to do it, or some people were missing because of sick leave or whatever. And the third pillar I already mentioned, the people who are women who could not just change their job. All that leads, is used by the employer to make those people work in overtime. There were two different, in my opinion, overtime types. One, which I mentioned, to deliver daily production norm. So they had to stay longer than regular working hours, just for free, just to deliver what was necessary to get this basic payment. And the second one was the gesture, sorry for the sarcasm, from the employer to give them chance to get some more money by working in overtime. This overtime, the reported case shows that it was almost every day, also on Saturdays. So I'm not surprised that some of them, even being in such a bad financial situation, said no. No, because they were so much tired. I read it was really touching. They said they were crying from being so exhausted. I think we cannot imagine working for many years, all the time, tired, and in such a circumstances. So not everyone could do this, and not everyone wanted to do this, because they also wanted to have a normal life. What means to be part of the family, to go to children with school, or just to play, or to have hobby, or some of them, they wanted to educate further. So saying no to the employer was not accepted. He was pushing. Managers were insisting, intimidating. It was a normal case that if you don't come, you will lose your job. And it was a threat, very realistic. If people didn't come, if they didn't show up on Saturdays, there were some cases where the salary was cut, this basic salary was reduced. Other problems in this company relate to working conditions, because there were no air condition. So in the summertime, it was very hot, 40, 50 degrees Celsius, and they could not use water. So they could not just drink in their working place. It was forbidden. Drinking and toilet use was possible only once per shift, 15 minutes break. We can make an experiment. Please don't go to toilet, don't drink before we leave this this aula. So this limitation led to another problem. Women felt discriminated, especially during menstruation, because they couldn't just use a restroom. Employer didn't pay social security or paid with delay. So employees experienced problem to access national health system. And this is reflected in lower retirement. And employees couldn't just say when they want to go for holidays. It is already annoying, but in this case where people were so much tired, it was a really a big problem. So one day on Saturday, so in overtime, desperate women said, no, please, let's talk. And they stopped working, but nobody wanted to talk to them. Instead, on next working day, on Monday morning, 3 of them, they were randomly chosen and punished by disciplinary immediate dismissal, with no right to severance pay. I said randomly because they report that there were no leaders. They just somehow they just said it's enough. And these women went to the court, and they wanted, the only thing what they wanted was to get the severance pay, because just to stay without any income for next few months. And I said it was not easy to find any other job. For them was very difficult to accept. And of course, the court agreed with these women, and the court ordered the employee to pay the severance pay. So everyone feels that it's not okay what I'm talking here about. I mean, this case, but thinking about human rights, what cases we have here? Of course, the right to work. This work was not freely chosen by them, as I described already. Right to fair living wage. This salary was not enough to have a decent life and to meet them basic needs. Exploitation, I mentioned the business model already. They had no possibility to rest enough. Women felt discriminated. Working conditions were not good, and I forgot to mention one case where one lady got an electrical shock because there was roof leaking for a long time, and during rain she got electrical shock, and she couldn't work for a long time. The employer didn't accept entire sick leave and paid just a part. putting himself over the law, over the medical instructions. So that is why working condition, safe and healthy working conditions, this right was also breached. Social security, I mentioned about the payments. And last but not least, the right to join trade unions and the right to strike. Describe situation where the employer dismissed disciplinary 3 women was only to intimidate them, to stop creating trade unions. So what we have here, in my opinion, it's interesting case also for students for future, because we have here states and the law, big companies, customers of this producer, and the company itself. And I will start with the company, because according to United Nations guiding principles on business and human rights, the state has obligation to protect that the human rights are respected. But so what we have here, the law in Poland, of course, the labor law exists, and it's good, I think, because it's in line. Piotrek, correct me if I'm wrong. Yeah. So what's the problem? The problem is that this law was not enforced. So in fact, state didn't executed his obligation to protect. And what would be now the solution is the inspection, labor inspection, because of course this inspection exists and visited that company many times, but apparently was not effective. We can assume that because this is such an important employer in this region, having a lot of impact on other businesses and people, and just as someone who can give you a job, or we, at least me, I expect that this labor inspection was not effective because someone was informing in advance the company about visits, about inspections, so the company could prepare properly fake documents, instruct employees what to say. Employees said that inspections were asking employees in a presence, with the presence of managers. So imagine how you, in such circumstances, these employees could say the truth. And the role of media is very important, because the best example is that I'm saying today, presenting this case today, because media can show the relationship between local governments in this case and the company, but also to make public aware of such cases. And the word which is coming to my mind now is reputation, because nowadays reputation for companies is sometimes more worth, the more value than tangible assets. So presenting such a case could be really a strong motivation for companies to change their malbehavior. And consumers, of course, if they would buy only ethically produced goods, the situation would be different. And now I'm coming to a very important stakeholder in this situation: big fashion brands, customers of the company of this case. Because fashion companies, big brands, are part of the problem nowadays, but they can and should be part of the solution in the future. Looking from the perspective of United Nations guiding principles, now I hope I will show to Beata that I learned something from our summer academy. The impact can be from three perspectives: cost, breaching of human rights, contribution, and directly linked. And in my opinion, this is the case where big brands contribute to the problem, because with the channels how they do it is through the pricing and lead time. Pricing in the fashion industry is benchmarked with companies and offers from Asia countries. And already there, those prices are very low. And replacing them, using them in European circumstances, it's simply far too low. And the second contributor is the lead time. Lead time means that the time between when the company gets order to the time when the goods has to be delivered. And because nowadays we have so-called fast fashion, when the model change so often, so the suppliers had really not much time to deliver goods. And as our case shows that those two aspects, we can see negative impacts on our right holders, on our employees. And so how brands can change it for positive? Of course, they should make good assessment. And they should change procurement policy. And talking again about prices and lead time. Lead time should be simply extended. It's possible, just planning in advance. And prices, there are companies who are transparent enough to show their books, to show their cost and margin. So we know it's possible. And even if it's hard, today, Ron Popper said that the time when only prices and profits are important should be over. So it's not an excuse. I got low prices, so I will make modern slaves from people. So this time is over. At least I would wish to be over. So the positive impact from brands could be through procurement policy, as I mentioned, but also very, very important is what also it's shown in the German Lieferkette. I knew that, but now I'm it's the grievance system. It's the pillar of the new legislation in German law and in the coming European directive to create an effective grievance compliance mechanism. So workers of the supply chain had possibility to contact the customer. And so I'm coming to the major actor of this case, the company. As English say, first things first, this company should obey the law and should obey the court order. Second, this company should improve health and safety conditions. But then on long term, more important even is that this company and the owner stopped obstructing establishment of trade unions or representatives of this company, employees of the company. And together, they start negotiations, regular rounds. It is recommended to use external facilitators, mediators, NGOs to facilitate this conversation, because especially when emotions are high, and this is the case, it is good to use external bodies. The effect of the common work should be code of conduct prepared together and internal complaint mechanism. This is what I wanted to tell you. So thank you for listening, and please buy ethically produced goods. Thank you.
Thank you very much. Mariusz, would anybody have any questions? Valeria?
Dear Mariusz, thank you for your presentation. It was indeed a shocking case. And my question will be about big brands' position. You said that the prices are benchmarked by Asian producers. So if big brands pay fair prices to the suppliers in Europe, they just become uncompetitive and exit the market. How do you see the way out?
I don't care. I mean, I know it's very strong, because for years I was maneuvering, and always, of course, at the end we should look at from the bigger picture, that here employees but as I mentioned before, it is not an excuse to reduce prices, to not to pay people only because the company must exist. And it's much broader aspect. So I don't care was of course not very emotional. It's also because, as I mentioned, it's complex. In my opinion, it's enough margin in this business to share fairly between suppliers and brands. But if it's not, because of any reason, I can imagine, then it should be the role for end consumers. Because do we need to buy every month, or maybe even more often, goods? I'm of the opinion that I would be ready, and I hope many people would be ready to pay a little bit more, and to know that this money is distributed fairly. So I don't know if I answered your question. I think no, but
thank you.
And I would have a question, because there are some companies who understand that they need to change what they are paying, and they would be willing to pay to the suppliers more, but they have absolutely no guarantees from those suppliers that they will actually pay more to their employees.
Okay.
Would you kind of have a way to go around it? Like if you were in a company that, yeah, you know, big brands, they want to pay a bit more to the supplier, but they want to be sure that actually workers are paid. Yeah, what would be the steps that you would take to make sure that actually this money trickles down?
I don't know if it's possible just to look at the books of this company, the employer, but if grievance system would be in place, then this company, the customer paying more, I assume would be informed immediately if this money is not transferred, the situation is still the same. So having open channels to workers, this is the best method. And that is why grievance system is the pillar of the new legislation on due diligence in human rights. So this is my idea.
To make sure that those workers know what they should be paid. And how do you ensure that you've got insight into the books?
Piotrek is trying to help me. It's like almost a millionaire, this game. Telephone to the friend.
So we are waiting for coming into force of the Equal Pay Directive, which forbids any confidentiality clause on information on wages. So in that case, the brands could directly contact employees of this employer and ask about how much they earn. So they will get that information directly. So we have this, excuse me? Well, this could be more difficult. Yeah.
I mean, some cases was presented with graduates. But there are some shifts, and some companies are trying to figure out what they need to do. So let's think. Let's kind of spend the next 5 minutes thinking what things they can implement to actually make change in the supply chain.
Okay, they can go for certifications, like for example, fair trade. So then the
That's a question.
I think maybe after this adoption of the directive, the European companies which are cooperating with the supply chain companies, they will probably require the observance of human rights, and maybe that will like certain monitoring, certain assessment, and in their own contracts with them, they will, if they add this provision that the company which wants to cooperate with the European company, they should follow labor standards, international labor standards, and this kind of contractual obligation will force them to follow these regulations. And if they don't, they will not cooperate with those companies. So I think this competition will promote the awareness and follow-up of international labor standards.
Thanks, Olya.
I already have, they just given me now. I'll take it to Bulgaria. I always have something to say. First of all, thank you. It seems that like it was very honest, and it seems that you're very passionate about this case. And I know that you were very nervous, but I think you should do this more often because you did very well. And what I wanted to say is that you mentioned things that we should be doing as consumers, and how we should be thinking how to change things. And one thing that I agree with you, it felt though that even though you're saying we should change as consumers, the women should be talking. My observation is that when we talk about companies, we need to change the thinking on top level, right? The decision making. And yes, we can give opportunities for these women to mention everything, but in the end of the day, we need to see some practical things that will happen. And from one point of view, we can wait for the whole legislation in the world if they don't want to do the right thing. And as you know, if they want to find a way, they will find it, a way out not to do it. And all I just wanted to say is that, yes, we as a consumers have something to do and we have a role to play, but also the investors, because in the end of the day, why would someone want to work with this company? We have now ESG coming into place, and really combining everything that's right there, looking at who can attack them to start doing the right thing. Because by the time the directive is implemented, by the time we have legislation, these women will need to have normal standard of living. They're working, they're receiving their pay. And yeah, just wanted to say that whilst we're waiting, sometimes we just have to start, making those little kind of suggestions. And I was thinking, who is supporting the women now as of today and as of tomorrow? What's going to happen?
Thank you, Olya. And we've got Kaya.
Hi. Yeah. Oh, there we go. Just wanted to go back to Beata's question. I have some, examples from my own company and what we're doing. on implementing human rights due diligence. So one thing was the contractual clauses, but another idea something we're implementing is having our own code that we audit against. That's one thing. And I guess getting directly to the worker, there's, I guess, new technology showing up for surveying workers and getting their input through worker voice technology. So that seems to be, the number one thing that we're hoping to achieve soon. And also in terms of informing consumers, there's a social value assessment that we're doing that gives kind of on a 5-point scale assurance to clients on, I guess, the social value. However, the methodology, is being not with stakeholder input. So that's something that also we're working on, is to see how different human rights due diligence requirements can now fit into the social value assessment to make sure that what the clients are getting is also relevant to the different regulation that's coming out. So I thought that might be insightful. Yeah.
Thank you very much, Kaya. We've got Markus. Mark, question from the internet, and Zanakak.
Thank you very much. Just two very quick observations. The first, reacting specifically to relying on inputs from workers from the suppliers. I was wondering whether there's already some empirical evidence that that's working, because I'm wondering whether the workers would not be afraid of telling the truth, because the consequence would be that the ordering company, the global brand, is simply canceling the order. So why would the workers of the supplier tell the brand the truth if the consequence is that then they all lose their jobs? Is there empirical evidence that that's working? That's the first question. And the comment more to the presentation is, thank you very much. I thought it was an extremely interesting presentation. And I'm just wondering, the way I read it, and I was wondering whether you would agree, or others in the room as well, is that when we look at the company itself, the supplier that you looked at, and then on the one side, on the other side to the brands, we can really see why the guiding principles are so important, but also why domestic law is so important. Because I think everything that the local company did is probably a violation of Polish law. So we don't even need the guiding principles for that. So we can just basically say there's a violation, and the government or whoever needs to implement its own law, and we don't need to discuss that at all. But if we then look to the brands, they're probably not violating any Polish law. So, but they are sort of not in compliance with the guiding principles. And I think so the case shows really well, when is it good to rely on the guiding principles and when actually we don't need them.
Thank you very much for this commentary, Markus. And Mark?
Thank you very much. I'll respond, if I may, to the first of Markus's points. And also I want to thank you very much for the case study. It's heartbreaking and all too common in our experience. There are, depending on the brands, there are brands that are very proactive with complaints by workers against their supplier factories. Some of them are proactive in the way that Markus was saying. It's very easy. If you give this report to a brand, many brands would say, I'm leaving Poland. I can go to Bangladesh. Why do I have to deal with all these problems here? You're violating our code 15 different ways. You'll never fix it. I'm gone. And then where's the factory? Where's the workers? Other brands will say, we have 15 problems here. Let's work on the first 3. Then we'll work on the next 3, and we'll bring you around and we can make this work. That is a lot more effort for the brand. There are still brands that will do it to this day, but I would say it's a minority will do it. Anyway, I loved the case study and all the thoughtfulness you brought to it. Thank you very much.
Thank you, Mark.
Yes, the case study is causing quite a lot of comments and reactions. We've got 2 online. One is actually a comment Business model of fast fashion is based on exploitation. Brands exploit their suppliers and they exploit their workers. There are talks in the garment sector concerning higher wages of workers in the value chain, how to assure that paying more to the suppliers is going to benefit workers themselves. As far as I know, there are no solutions to this problem yet. So there is just one comment from an anonymous participant. And then another one, it would be interesting to know how human rights are perceived in Eastern Europe, for example, by the owners of big Polish businesses. Do they respect their own workers? Are they conscious enough to perform due diligence while working with their suppliers in Poland or in Asia?
Thank you, Kasia. I'm not sure if we are able to answer the second question.
But we just wanted to honor all the participants that are with us online still. Thank you very much. And thank you for following the case.
Definitely. And then we've got a question from Akaki as well. Question or comment. So.
Okay, thank you very much for your presentation. I liked how you identified the problems, the real problems you were speaking about. So my question is whether you believe that the grievance mechanism inside company can be effective, and or you think it is important to have external something, not internal. And if I'm interested about the effectiveness of this kind of compliance systems, and if you believe in it, what are the criteria for having an effective grievance mechanism in the company? Thank you.
Yeah, I'm asking about believing it's a good place. Poland's a good country to ask about believing or not. So I believe that this mechanism can be effective, and I based on my hope on a German company, which the case I saw very closely, Wende, the producer of outdoor equipment, clothes, and also the supplies are from Asia, of course. And they introduced grievance mechanism, but they did it in a way that it's effective. They used local companies, speaking, of course, language. I think it was in Vietnam. Local language, local circumstances. I saw how it looked like. So it was not just a sticker somewhere on the wall. From now on, you can write in English or German, German better, under this email, and that's it. No, they came and they were talking. It looked like a primary school. Hundreds or maybe thousands of people. Really, it was amazing to see. They were sitting like we are sitting here, and they were listening what they have to do. It was step by step, so straightforward. The employer has to pay you every week. How often the employer has to pay you? Every week. So it was like that. If the employee doesn't pay you, what you can do? I can call my I don't remember now, but I'm just a little bit acting right now, but it was just giving them so straightforward information, and at the end everyone got into their hands a piece of paper with the telephone number, of course in their language, where they can contact if something is wrong. And the employer, the owner of the company, was staying next to this NGO guy, showing that he's playing with, that he's making with. So I believe, and I think this is the reason why I'm gonna repeat, the new legislation, the grievance mechanism is the pillar for this regulation. And if I'm not wrong, because I was also reading about BAFA in instructions were saying, if you don't do everything, we understand that it's a beginning step. But if you don't introduce grievance mechanism, we will make you pay. So I think the understanding, the grievance mechanism is the core, is there. Thank you.
Thank you very much.
Thank you.
Mariusz, for this case and the answers. Many thanks to all who commented and provided questions. And now I would like to give the floor to our final presenter for the day, Nana, and I will skip the last name. And Nana will be talking about the corporate benefits over human rights on the example of ferroalloys production in Georgia.
Thank you. Good afternoon. Today, I have the honor to show you a presentation regarding corporate benefits over human rights. Before we start, I just wanted to highlight that is, of course, a real case. However, for the purposes of this presentation, we're just gonna call the company Company X. So the Company X is a Georgian subsidiary of a British company, which is located and has quarters in Tbilisi, which is the capital city of Georgia. However, its main business is Chiatura, and it's doing business regarding mining and ferroalloys. So the case started in 2016 when the company introduced new regulations regarding the way they operated. So for instance, a working shift of the miners changed and it became 12 hours working shift. And also they started to deducting wages if certain quotas were not met. Occupational health was one of the important part of this case because, as we mentioned, 12-hour shifts was continued over 15 days, and this was without breaks. There was also environmental risks in practice because the company did not pay enough attention to the circumstances that this overload of mining practices was having. And also communication risks because locals of Chiatura had no idea what was really going on. The what can be, I just skipped, sorry. So right holders and stakeholders of this case are certain peoples, and they're same. It's miners and residents of mining location. So miners which continued to working and residents are quite similar people, and the continuous working we are not stopping because 70 to 80% of Chiatura residents were actually having this only source of income from these mining practices, which means that even though certain accidents occurred, to give up their source of income was very hard for them. And the troubles of the mining practices started from the introduction of the, of course, incidents and the new vacations. And only in 2017, there was already 60 several injuries and 1 fatal death. And for 4 years, there were 4 fatal deaths and much more injuries and so on. All those incidents, of course, took up notice from Georgia's government and also the world, which was in shock how these procedures were going. And the other parts were undoubtedly several reactions that took place. And there was also question of what can be done. And the first, of course, is to conduct a human rights impact assessment, which is to identify and prioritize human rights. Because today it was mentioned several times how we all know a certain degree that we are having human rights. However, our understanding of those rights and what it has implications or what can be done is much different. And even though those workers knew, of course, that they had several rights, even labor rights, they didn't know how to actually do something about it to make their work and life better. That's why provide human rights training comes in place. And not only to the workers or the company, which has an idea what they are doing, but to the middle people who are actually having direct connections with them. And that can be contractors, suppliers, employees. So they will understand what their power is and try to navigate it better. And this is established grievance mechanisms. This was mentioned already in several case studies, because this is one of the best solutions that the company can actually establish to enable individuals to have direct communications. We mentioned how locals were one of the stakeholders and also right holders. And these residents need to know how their relationship with this company can be regulated in a better way. And engages with stakeholders like miners and local communities are an important step. We mentioned how this one of the impact is on the earth itself. So how this ground between and around their houses are shaking. So they are not only struggling to lose their jobs, but also the houses that they probably stayed for generations. And now about the solutions, which are several international organizations that needs to be mentioned in this regard. And one of them is NCPOSD. We had quite amazing presentation regarding this matter. However, unfortunately, Georgia is not currently part of this organization. There's no way that anybody can have a direct relationship with that. Another is International Labor Organization, and this organization has complaints mechanisms that will allow individuals or groups to submit complaints. Then we have Human Rights Committee, which individuals can have submitted complaints about. Then we have CSHR, which is Committee on Economic, Social and Cultural Rights. And then we have ACHR. ACHR is quite complicated because for an individual to submit a complaint in ACHR, there needs to be all the local steps to be done. However, we mentioned this that complicated situation in Georgia meant that there was very, very hard trying not to go even to the court and try to settle the case. And that happened, even though the complications continued, there was not even first step happening. So ACHR should be the last one, and there's a long way to go between that. So what was impacts and conclusions? We mentioned that because of these incidents and several injuries, the Georgian government reacted and actually saw that after a long time, there was a change needed. So there was a special committee organized for this company only. And one of the things that they tried to actually work with was the river that Tietura has, and it was drying up because of all the impacts of this organization. However, it's been more than 5 years and this river problem is still present, not to mention that human rights violations are still happening. So they tried to change committee members because they thought that the relationship was quite not as public as it's supposed to be. And then despite those changes, we mentioned that the company is still going on and is of course working on those practices. However, minors need to know much more about their relationship with not only to the organization and the companies that they are working with, but also to a general public and what they're supposed to do in this connection. Business and human rights are very directly linked, and this link is, of course, strengthened by the knowledge for all the players. And to understand the situation better, the knowledge will be much more useful power for it. Thank you. That's all I had to say for now. I would gladly answer any questions if there's any present.
Thank you very much, Nana. And we already have the first question.
Thank you very much. You said that the NCP is not available for Georgia. Have you considered addressing the NCP in the UK? Because you said that this is a subsidiary of a British entity. So have you considered contacting the UK NCP?
Because even though it's a British subsidiary, the company is actually registered in Georgia and is operating in Georgia. I don't think that will be much possibility with that. However, I don't know why the other right holders or stakeholders did not take that step. Maybe it's lack of knowledge at this point also.
Thank you very much. Anybody else? I'm just looking at Gosia, if there are any questions, nothing on consent internet. No comments? No questions? No doubts?
Thank you.
Okay, so in that case, thank you very much, Nana, and congratulations once again. Sorry, I just have something with cables today, it seems. Right, so we are at the end of the day. And we still have a couple of minutes, and I'm not intending to keep you just for the sake of staying here. But are there any questions? Are there any issues? Are there any comments that you would like to make at the end of the first day? Because tomorrow we'll have a networking session in the morning. And then in the later morning, we'll have two groups where other authors will present their case studies. And we'll have the discussions in those two groups. Then there will be a break for the lunch, and then those who will want to participate can participate in the simulation game, where they can actually try to see how it is to negotiate a lower price of an item while also trying to stay on the positive side and keep it sustainable. So a little bit of practice. But how about now? Are there any outstanding questions? If not, I would like to thank you very much for the attendance, both in person here and online. And I would like to encourage those who are here to pick up a copy of the publication on your way out to the refreshments. And for the people, for our guests, basically, we will meet at 5 in front of the building. There will be minibuses waiting for you. And we'll just move for the evening. And Gosia, have I forgotten something? Thank you. Sorry, I constantly seem to be out of the frame for online participants, so they just hear the voice, and there are basically ghosts in here. So, yeah. So thank you very much for today. Thank you very much to our presenters for showing, for telling us about the cases that they've chosen to write about. And well, enjoy the refreshments. There was not enough of time to talk during the breaks, and we had, I'm looking at Markus, who was lobbying for longer breaks, and not to put you on the spot at all, but now there is a time to catch up and to talk to people that you didn't have enough time to talk before, and we'll see you at 5. Thank you.